Does that help you?
Thank you.
So on the per unit or the per well or per unit basis, the wording of the statutory change supports this interpretation. It operates on subsequently drilled wells in the drilling unit. Those are two different things. It's not simply the drilling unit. These are operating on a well by well basis within the drilling unit. This is the exact same argument that Newfield made in the Axiomatter 2017-010. The 2018 change in the statute doesn't alter the analysis at all, in my view. The default rule may be to apply the JOA to subsequent rules, but only if everyone defaults. If no one says anything, the order continues forward. That's the proposed rule as written, this subsection 13, which, again, we think is a fairly well-crafted rule. And the testimony of the State House supported this. And I'd like to play a brief excerpt from that testimony once I clear off all my.
Okay, and so it says in here something about that somebody might not choose to cooperate, but they will still be stuck with expenses and should receive some of the compensation too. Is that if it's within
the statute? The statute wouldn't change the provisions that deal with that party, except that what the compulsory pooling allows is if they don't voluntarily agree to participate in a well, they still get what's called a cost-free royalty. So they still get a royalty out of it, but the portion that would be cost-bearing, the parties are allowed to recover 100% of that, and then there's a risk compensation based on the nature of the well. For example, let's say it's a highly wildcat well, very risky well. Then the board would be more inclined to give a higher risk compensation award, which the maximum is 400%. As opposed to, for example, in this horizontal wells, if they're on the 38th well, and it's pretty much like shooting fish in a barrel, the board may be inclined, if somebody petitions it, to impose a lesser non-consent penalty, which the minimum is 150%. So that's how that's done. So the idea is that it by compulsory pooling, it allows development to go forward without one person preventing it, and it also allocates the risks that are taken with that well between the parties. And constitutionally, that forced pooling power has been upheld by the courts.
So I counted 6 times Mr. McDonald mentioned the well, and that analysis is well by well, up to the 38th well perhaps. And also notice that he also mentioned the fact that someone needs to come and petition the board for that. Something needs to happen. A hearing needs to be held. Evidence must be gathered, testimony, the board needs to make a decision. Any barrier between that evidentiary hearing that can let somebody make a case is a problem constitutionally. So I'm just going to read some stuff because no state shall make and enforce a law that shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within this jurisdiction the equal protection of the laws. That's the United States Constitution, Amendment 14. We can drill down a little bit. No person shall be deprived of life, liberty, or property without due process of law. That's Utah Constitution. All courts shall be open, and every person for an injury done to him in his person, property, or reputation shall have a remedy by due course of law, which shall be administered without denial or unnecessary delay, and no person shall be barred from prosecuting or defending before any tribunal in the state by himself or counsel any civil cause to which he is party. That's Utah Constitution as well. This one I think is a stretch, but I'm including it because Mr. Gunnell put it in his letter. Excessive bail shall not be required, excessive fines shall not be imposed, nor shall cruel and unusual punishments be inflicted. He referenced the United States Constitution, 8th Amendment. This I find to be the equivalent of the Utah Constitution. I'd need to do a little more research before I buy that fully, but I'm just bringing that up because he did. Because at the bottom of all of this is that the state has the right to exercise its authorities under the conservation statutes, pool and unitize, impose non-consent penalties. This is all well-settled law. It's the extent and the manner and the type of costs that are going to be borne by the non-operator to the benefit of the operator that are at issue. Up to a certain point, it's exactly how the rest of the industry runs. It's exactly how these conservation statutes have run for nearly 100 years now. The 30s were when they were first adopted in Oklahoma and I think New Mexico. So it's been doing fine for a long time the way it's been. These amendments, though, are stretching things. So let's talk about the scope of the statute here. My animations didn't work quite right, so I'll just go ahead and fill them all in. Each pooling order shall provide for the payment of just and reasonable costs incurred in the drilling and operating of the drilling unit. Two things. You drill it, you operate it, including costs of drilling, completing, equipping, producing, gathering, transporting, processing, marketing, and storage facilities, reasonable charges for the administration and supervision of the operations, and other costs customarily incurred in the industry. And that's from the pooling statute. What did the legislature mean by customarily incurred? Well, they tell us in the rest of the pooling statute. Wellhead connections, stock tanks, separators, treaters, pumping equipment, and piping, staking, well preparation, rights of way, rigging up, drilling. I won't read the rest. It's that universe of things that is what they're looking at. When you're talking about recovering pooling costs, the cost to operate a pooled unit, drilling unit, this is what you're working with. So I'm going to play very briefly testimony of Ms. Leslie Gadd and Mr. Taryn Franzel at last month's Axia Energy pooling hearing.
So under L, gathering, transportation, marketing, lease fuel and water source and disposal. Under L2, under A, there's a fee for gas-related services of $1.15 an MCF.
Yes, that's to recoup some of the cost of those pipelines. Those gathering lines are incredibly expensive to put in place, and without them, you can't get anything to market. So the operator should not have to bear 100% of those expenses. The working interest owners who are bearing those expenses.
So does Axia own those gas gathering lines?
Correct.
What
We have
is,
the permits for them, we built them, we laid them, etc.
I understand. What is Axia recouping on the sale of gas at the marketing points it discusses?
We're trying to recoup the cost to get those lines in place. To get the permits cost money, the surface agreements cost money, the lines themselves cost money to lay, to bury, to do all that stuff.
Right.
So all we're trying to do is recoup some of that money
Right.
to get the gas to market.
I guess my question is, what do they sell the gas for? And is there any net value of that gas to the working interest owners that signed this JOA?
Yes. What they sell it for would depend on the price at the time it got to market. It's not always the same amount of money every day.
understand
So everybody, all the working interest owners will get their share of that, as well as the royalty owners.
But they're paying Axia $1.15 to gather that gas.
Correct. Oh,
There is a fee for water supply of $2 a barrel.
we'll let you answer.
That's in B.
You want to take that? You were gonna.
Sure. I'm going to add on the gas gathering fee. It's not always Axia. Axia goes to Kinder Morgan. Kinder Morgan charges us north of $1 to take our gas into their plant and get it to the big system. So it's really a pass on of what we're getting charged per MCF on our gas. On the water side, it's the cost of disposal, $2 a barrel. We have the right to dispose and handle theirs, or they can handle it themselves. But if we handle it, it's $2 a barrel, which is a standard commercial disposal fee.
Mr. Boulder, could we identify the witness?
I'm sorry.
Yeah, can you state your name?
Taryn Frenzel.
On both of these charges, what is common industry charge for gas gathering and water disposal?
I can only say that on other JOAs, $1.15 has been the standard that we get from like Newfielder and Canas. So that's passed on. It's all the same, and that's pretty close to what we're getting charged with Kinder Morgan. On the water side, $2 a barrel is also we're actually paying $2.25. So it's more than current cost of disposing of water.
Thank you.
Mr. Moon.
There's a lot to unpack in that little 4-minute or so clip. Starting at the beginning, the question to the witnesses was, or the witness at the time, Ms. Gadd, Mr. Frenzel hadn't started his testimony yet, was, what's the $1.15 for? The answer was, we're recouping the cost of gathering. After further discussion, well, who owns it? Axia. Who pays for it? The working interest owners. The working interest owners are paying for something that they won't own. That's not authorized in the pooling statute. That's not something that you get a recoup. That's a capital expenditure by the operator, and it's not going to benefit the working interest owners, and it's not directly going to benefit the spacing unit. That's point one. Point two is that the disposal, we heard conflicting testimony, at least conflicting evidence. The contract says that the $2 a barrel is for drilling water. And this testimony here was that it was for disposal. So I'm a little curious as to what that is. The important point here is that drilling is a non-consent penalty at 300%. So what you charge for drilling water, you get a triple that on the back end on non-consenting owners. Disposal water, well, supposedly that would be an expense, which would be, 100%. So all of these little bits and pieces, the tiny little nubbins of detail at the very bottom of Article 16 can swing the economics for a small non-operator or landowner who's not leased. And they have no idea it's in there, and they won't be able to argue about it or get relief from this board until, under this proposal, they pay for their share. They can't seek relief or get that provision looked at, analyzed, taken out, hopefully, until and unless they write a check. One of the other questions that was asked was there any benefit left to the working interest owner? And the answer was essentially yes, but prices fluctuate, et cetera. This is NYMEX gas. This is the most heavily traded natural gas future in the world. By some accounts, it's the third largest commodity by volume traded anywhere. This is the best price you would probably get for gas, or at least the most liquid one. And it's not what you get in Utah. It's hard to see, but I'll submit these for the board as well. The important piece of it is along here on the side is the dollar figure. The blue graphs fluctuate at the low end between 2.0 or $2 on the left, which would be the fifth one up, and then at the very top it hits 4 at the most expensive. This goes from approximately end of 2017 to the beginning of 2019 is the time frame here. You'll be able to see the details, and I'll be happy to answer any questions you have about them if it's not easy to see. But the next slide here is really what I want to talk about. I put a green line on that graph at $2.30. That's $1.15 for Kinder Morgan, and that's $1.15 per MCF, which is a separate charge, because under that contract that Ms. Davis was asking about, the Kinder Morgan piece was a separate entry. There's a bit about $1.15, and there's a bit about recouping from Kinder Morgan, also north of $1 according to the testimony. So I put a green line there at about $2.30. Everything under the green line is eaten by the operator as soon as the gas comes up out of the wellhead, which leaves above the green line left over for anything else that they want to charge, because the rest of the JOA contains provisions that you're allowed to recoup expenses. Why would you need specific line items for a $1.15 marketing fee and whatever Kinder Morgan's charging you if you already had authority in the rest of the JOA to recover your normal expenses? By very strong implication, and I'd love to hear arguments to the contrary, these are separate things. They haven't charged you for expenses yet. They've hit you twice, and you haven't even gotten to the expenses yet. I'm happy to entertain arguments to the contrary by anybody who would like to make it, but having those separate items in there in the Article 16 special provisions, I think is pretty convincing that they're separate. As we all know, though, you don't get the best price. You get what's local. This is the Opal Hub. It's probably the best I could do as far as what we're going to get here in Utah. This is in Wyoming. You can see this one's a little easier to read, but it fluctuates between $2 sort of there at the bottom, and there's a spike in late 2018, early 2019 where it hit north of 5. But I'll put that same green line there at about $2.30. And you'll note that at least twice, if the operator can charge you $2.30 before they even start making deductions, you're underwater. An order authorizing those expenditures on non-operators was authorized by this board last month in the findings, in fact, conclusions of law and order. This is what's going on. The green line indicates a $1.15 MCF charge and the recovery of the Kinder Morgan pass on. It's a capital cost recovery. It's not authorized in the pooling statute. Docket 2017-010 has special personal meaning for me because at that hearing, later on, it was mentioned by Ms. Gadd that International Petroleum never signs JOAs. That is not true. There is evidence in the administrative record that that is not true in this docket. And this is especially interesting because this docket had a JOA attached to it with these exact provisions that Ms. Davis was asking about. And I had a phone call with Rick Gallegos to discuss these issues. And he related to me that it was a capital cost recoupment. And the International Petroleum signed that JOA because at the initial point, they felt it was contractually fair. They felt it was fair for that first well that maybe, this is the only way we can break Kinder Morgan's stranglehold on getting gas out of the basin. Maybe, Axia is trying something new and different and we're willing to take a plunge with them. They signed it. At this most recent one, as you heard, they did not sign it. They had it imposed upon them. Because it's a subsequent well. Things have changed. I'm just hitting this as hard as I can to enunciate, this is not a drilling unit situation. This is a well-by-well analysis. Each pooling order shall provide for the payment of just and reasonable costs in the drilling unit. I think this might be a duplicate, sorry. Oh, another duplicate. Well, I really, really wanted to hit that hard, didn't I? There we go. Bottom line is that there's already a law that takes care of the UPA's issues. There's no statutory non-consent penalty, but unit operating agreements contain it in their standard form. It requires unit agreement approval by 70% of the working interest owners and 70% of the royalty or mineral interest owners to qualify for compulsory unitization. But as we all know, pooling requests typically hit 90 plus in the working interest owners. You do have to go ask the mineral owners nicely, which is a burden, but they're already running down estates. They're already tracking down dead folks. They're already dealing with, family squabbles. They're already doing a lot of this stuff. The unitization statute, it's an agreement for what we usually think of unitization concepts, and let me stop for just a second here. Usually when people talk about unitization, they're talking about pressure maintenance, secondary and tertiary recovery. The oil field's been depleted, we need to flood it with water or CO2 or something. That's typically how people think of unitization, but that's not what the statute says. Other methods of unit or cooperative development or operation of a field or pool or a part of either is authorized and may be performed. The board can hold a hearing to consider the need for the operation as a unit of one or more pools or parts of them in a field. Now, I want to talk about the comment letter by Geopinion Mr. Adamson, who you heard from a long time ago at this point, last year probably. His point was that when you pool a single source of supply that's 3,000 feet thick and contains 9 potential horizontal targets and 6 primary targets with petrophysical models identifying frac zone height and zone frac boundaries, you're not really doing one source of supply anymore. Your drilling program may create one source of supply if you commingle all these fractures and zones, but in nature, there's a bunch of different ones. And pooling it, spacing it first as one source of supply and then pooling it as one chunk is, again, not the traditional way that you would space or pool something. You're a little outside the lines on that one. You're square within the authority in the unitization statute, though. It's a fundamental axiom that a common source of supply is drained by one well in pooling. That's how it's supposed to be. As I said, we've gone beyond that a little bit with legislative changes, but that's how it's supposed to work. It's why unitization is different than pooling, and why going to the mineral owners and getting that 70% threshold as part of the due process is a piece of it. Here's all the great things that the unitization statute does. I'm just going to read the underlined parts. Capital investments, owner who does not pay, first and prior lien, non-consenting owner shall be deemed to have contracted, there's their contract with the unit operator, shall not relieve the transferred interest of an operator's lien. You can't just sell it and get out from underneath an operator lien. Financing, people who want to be carried, you can charge them interest explicitly under the statute to do it. Supervision and conduct of unit operations, you can in fact charge for your work that you do. As a matter of fact, there's a great line in there. Services and things of value. Let me see if I can get this right because I love it. All things and services of value. If an operator has provided a service or a thing of value to the unit, it is perfectly fine to charge that, which is an extremely flexible way to approach this, as opposed to the pooling statute, which says you get 300% for these lists of things, you get 100% for these lists of things, 150 for these lists of things.
This is a quick question to make sure I'm clear on that. Under the second bullet, all things and services of value, are you including in that, or your understanding or what you're arguing is that title and curative work, surveys, rights of way, permitting?
As a recovering title attorney, I would definitely tell you that a title opinion is a service of value. I don't think Fred's going to argue with me either.
Thank you.
It gives a broader scope of authority to develop resources at scale because that's how it was designed. It's designed to combine multiple fields, multiple pools together, much like the layer cake development or the cube development, however you want to term it. This is what it was supposed to be for. When it was written back in the 30s or 50s, no matter the last time it was revised, the concept was a broad acreage area. Federal exploratory units is the most common one you're going to find here in Utah. But it also works to commingle or work together to cooperatively develop multiple layers, multiple zones, multiple strata. Turning now to the specific proposals, 8A is extremely problematic. This is the AFE prepayment requirement. I've gone through exhaustively all the things that I think are wrong with it. In my view, in the view of my clients, it's not worth saving.
Now let's be clear, that's 649-2-8A.
I hope I've got that citation right. It's the 8A. It's the one it's the proposal for including the prepayment of the AFE prior to having a hearing. Now you got me worried that I didn't put the number on it right.
I'm just looking at what you sent in on the proposed alternate regulatory language, and I'm not seeing an 8A.
It is on my written comments where I say it should just be deleted. It's not in the proposed language.
Okay.
8A is not currently enumerated in the administrative rule. It's just a brand new numeric rule. And in my client's view, it should just be taken out. Substituted in with revisions to 9, which should be on that, on our written.
Yes, we do have 9.
our view is that you start with the concept that a consenting owner under Utah law has got one job. You got to consent and agree to drill a well. You have to manifest that consent in writing, as currently required by the regulation in place now, in writing within 30 days. In my client's view, that has worked, is working, and continues to work. So we don't view that that piece needs to change at all. An owner is not required to execute a JOA in order to consent to a well. That's not in the statute, and I don't think it needs to be read into it. I don't think the board has the authority to promulgate a rule that says so. The legislature would have said so, but instead they chose to give the board the authority to impose one after notice and hearing. I'm going to hit that one again. The owner is not required to pay up front. There is no authority for that anywhere. It goes beyond the manifestation of agreement. That's performance. The performance of paying the AFE, the performance of participating in the well. And that has yet to be mandated by pooling order in this in the proposed 8A regulation, which we think should just be deleted. Until there's a pooling order, there is no obligation for anyone to do anything. The content of the JOA is a make or break decision for non-ops. Can make a good well into a bad one, as I illustrated with my little charts at $2.30. Absent those two charges, there might be money left over in the gas stream to distribute to royalty owners and working interest owners. But that Article 16 provision extracts massive amounts of volume in favor of the operator at the expense of the non-operator. Article 16 in the 89 revision Form 610 and the bespoke provisions in the 2015 Form 610, which still says 1989 on the cover, and there's an example in the administrative record on that. All these pieces require exquisite analysis, detailed analysis, because you don't know when that sentence or that clause or that paragraph that's going to charge you $2 for water, drilling water, probably, maybe disposal water if we have that testimony, where that's going to crop up inside the contract. Authority exists in the standard JOA to recover expenses related to gas, transportation, and water disposal already. In the 1989 Form 610, it's already in there. You don't need the special clauses. They require that extra scrutiny. That's what. Comment letters submitted by Gail McKechnie and Reed Lambert in the informal rulemaking alluded to affiliate relationships which are not transparent to the non-operator at the time the election letter goes out, at the time the JOA is sent out, nor, to be quite honest, during the life of the well. It is not transparent at all who is billing you for that water. Who is billing you for the gas transportation services? Now, it may seem like I've been picking on Axia a little bit, but I'm really not. They've been pretty forthcoming about stuff. I had a conversation with Rick Gallegos, and he told me the exact same thing that your witnesses told you. They're not playing hide the ball here. They're telling you what's exactly going on. I'm just telling you it's not authorized by the statute, what they want to do. They've been a little kind of transparent about this, but other operators are not. They don't tell you where they're buying their water, whether it's an affiliated company. They don't tell you who they're selling their gas to, whether it's a third-party arm's length deal, whether they're being robbed by Kinder Morgan, or whether it's an actual a company they own. We'll sell you the gas really expensive, or we'll sell you the gas really cheap because our corporate entity will end up profiting in the long run. We have no transparency on that when we get the JOA. We have no transparency on that when we get the election letter. The cost of the well should be borne by all parties equally. So should the benefits. It may not be fair for the operator to pay the expenses of putting in the gathering system. There's some validity to that statement. But then if the non-operating working interest owners are paying for it, they should own a piece of it too. The testimony was the working interest owners are paying for it, Axia owns it. I don't think that's exactly what the legislature had in mind when they put together the pooling statute. If predictable rates of return are made from disposing of salt water or by gathering gas, these companies are oil field service companies masquerading as operators. Again, not the way these statutes are designed to work. The benefit to these companies should be from the sale of the resource, the production of the resource, the prevention of waste, which is one of the two duties of this board. They are not here, the board is not here. The legislature did not authorize this body to ensure that drilling companies are profitable. It's not your job. The job is to produce the resource and protect relative rights. And to the extent that incentives are not aligned with those two things, I think that you have a problem exceeding the authority the legislature has granted you. They're not utilities. Utilities are regulated monopolies. They're entitled to a rate of return on capital expenses. They will tell you they're not banks. They will tell you they're not utilities. I agree with them on both points. And so therefore they should be treated as operators who make money producing the resource and protecting relative rights. Moving forward to the unlocatables, Mr. Lambert commented on this as well. He said there may be an incentive to skimp on locating owners. I'll go one further. There is an incentive. I made an extensive footnote in one of the filings in the Furlong case in 2015 that detailed exactly how that works. You get 300% for drilling costs on non-locatables because they're non-consent. And if it costs you money, as we heard testimony in the Axiom matter, that it's time, it's trouble, it's shoe leather, it's frustration, it's headache to track these people down just so you can get them leased up and only recover 100% and pay them a royalty and have to worry about getting them in your pay deck. There is a strong incentive to just not find people. And as a former landman, I sympathize. I truly do. And there are bottoms of barrels that really you'd rather not scrape. But that's not the problem for this board. The problem for this board is to align incentives properly, encourage people to find those people, and then, if it doesn't work, resort to the unitization statute, which is a 70% threshold. Get your 70% approval, bring it to the board. We believe the following clause should be added: restricting non-locatable owners to the 150% penalty. They didn't have a chance to decline to take the risk. They didn't have the opportunity to say, oil and gas business is not for me, this is far too complicated. They didn't have a chance to hire some attorney somewhere to explain all this to them. They had no clue because they were not locatable. I would argue that the same goes for people who are unidentified heirs or people who haven't finished their probates. It just doesn't make economic sense for some of these small probates to go through the expense of straightening out that title. So you're penalizing the heirs of mineral owners, property owners in the state, and incentivizing the operators to ensure that it doesn't get straightened out. Because it is more profitable in the long run to recover at triple than to pay at single.
Mr. Hunter, we're going to take a break sometime between now and
I have
12:30.
2 slides left.
I didn't want to interrupt you other than to say if there is a natural breaking point, let me know.
In 2 slides, that'll happen. 9B, this is the risk compensation award. There's a reporting requirement in the non-consent portion of the statute that you're supposed to get a statement. That needs to get beefed up in our view, especially because, as I mentioned earlier, there's questions about affiliates, there's questions about these capital recoveries. There needs to be a pretty detailed statement with some teeth in it and part of the board's order that non-consent accounting goes out with regularity and with specificity. Because that is there's no way even a non-op who's paying attention is going to have the kind of insight they need in order to make reasonable calculations as to whether or not that interest that they went non-consent with is ever going to make money ever again. And that goes back to the takings issue, which and the excessive civil fines that I think needs more research. But if it turns out that the imposed non-consent order extracts all the value from the working interest owner, even after the recovery of the non-consent penalty, it's a taking, in my view. And again, it's worked for years without those strange Article 16 requirements. It's been upheld without those Article 16 requirements. The unitization statute works. We also believe that the board should not consider evidence of general business risk, time to pay out of the well, title or ownership issues, legal risk, or anything else in the determining the non-consent penalty. The non-consent penalty, or the risk penalty assessment award, however you want to term it, it should be a measurement of the geological and engineering risk of drilling a well. That's what's in more or less the control of the operator and the working interest partners. They can, if the information is shared appropriately, make an educated guess as to whether or not a well is going to pay out. They can make an educated guess as to whether or not there's sufficient experienced contractors who can drill appropriately and not lose tools, et cetera. Those things are within the control of the non-operators and the operators jointly together. Price of oil, war in the Middle East, all that other stuff, interest rates, nobody has control over that. That's just general risk. And that should not be a part of the analysis. And then finally, as I stated almost at the very beginning, the affidavit of Tim Furlong establishes that it's hard for out-of-state people to necessarily get everything done that needs to be done within the 30 days that's been proposed on that regulation, and then keying it to the mailing of the motion to amend the pooling order shortens that already difficult time period. If they're out of town, you know, they for example, Mr. Furlong and Mr. Garcia live in North Dakota and live in Utah. They have residences in both places. So if they're out of town for a week and don't pick up the mail, that's a week that's not available to them. So in our view, it's just keying it to the receipt of it is a more equitable way to handle it. And that's the only thing that we have an issue with on that section. Otherwise, it's, in our view, a well-crafted rule. That concludes my presentation in chief. I'd like to have, if we want to take a break now, that's fine, but I'd like to reserve some time for Mr. Furlong to come up and make some comments if he wants.
That's a natural break in place. Let's just take a break now for 5 minutes, 5 to 7 minutes, and then we'll have Mr. Cronin come in, and then whoever else you would like.
Thank you.
Board members, are you ready? Michelle? Council, are you ready? Okay, we're back on the record. To you, Mr. Hunter.
Thank you, Mr. Chairman. I have here at the table with me Mr. Tim Furlong, one of the interested persons that submitted a request letter, and Mr. Brian Wixom, another one of the interested persons who also submitted a letter. Mr. Furlong is going to speak for a few minutes, and then Mr. Wixom. I would then like to make a brief closing statement, and then want to ask the board's opinion, indulgence, however you want to put it. Typically in a case, there's the case in chief, division, respondent, and then brief rebuttal. I would like to have a brief rebuttal if that's allowable. If we can time limit it to 10 minutes, however the board sees is appropriate. But I'd like to have that opportunity.
Okay. And who did you say? I have Tim Furlong. Who else is here?
Brian Wixom.
Thank you.
Does that seem appropriate to the board if I had a brief rebuttal period at the very end?
I'll ask the board about it at the end, and we'll decide at that point. Okay.
Very well. Mr. Furlong.
My name is Tim Furlong. I'm the president of JP Furlong Company. Appreciate the time to speak here, and I really didn't have too much to add to Tony's presentation.
If you would speak closer to the mic. I'm not picking you up on the recording.
It's Tim Furlong, president of JP Furlong Company. Appreciate the opportunity to have a few minutes to visit with you folks today. I'm not going to talk too much about what Mr. Hunter already has spoken of. Just to give you a little background, I'm in 528 wells as a non-operated interest. I'm under about 33 ducks. The ducks are drilled and uncompleted wells, and currently under 12 permitted wells that are not drilled. So I feel that I have a little background on this matter, especially coming from a non-operated working interest holder's view. Also, I think as I've testified before, I've been on both sides of the spectrum here. We operated and we've had non-operated interest, and also royalty interest owners. I wanted to just point out a couple of things. One is the non-consent accounting that we don't receive, or which includes the penalty. So when if we do go non-consent as a non-operated interest, or you're taking non-consent as a non-operated interest, you are supposedly supposed to get accounting to let you know where you're at in that process of payout. And generally, it shows the actual cost of the drilling and operating. Will show what the operating costs are every month, and then it will show the penalty amount, so you know exactly where you're at in your accounting. Many times we've begged operators to give those things to us, and just to no avail. We just don't get them, and there's really no regulations a lot of times to make them provide those to us, and I think that that's important that we tighten that up. The other thing Mr. Hunter was speaking of is third-party affiliated companies, and it's kind of interesting as I sit here and listen to that. I've been involved lately with selling frack water to an operator. And so I provide the frack water to an operator at 30 cents. I also happen to be a non-operated working interest under the well in which I got a bill. I was charged back 80 cents for the same water that I charged 30 cents for, and it was under affiliated. So just call this operator A. They had another company started that was set up to charge back the operator additional monies for that water. In this case, it was called Hydro Services, and Hydro Services is made up of the CEO, the CFO, the head of operations, and a couple of other people. So I would feel that that's pretty affiliated. That's an affiliated company to the operator, And this is a runaway train. That's just one example that I know, that I have facts on. And it's going on quite a bit. And so those things I think are going to have to be tightened up also as we go along here. It's gotten to be pretty bad. I will just flat call it criminal activity, but it's an issue. And all the gas charges, we're actually under most of our gas, we're being charged enough that we're going into a negative line item on our revenue. So we're being charged back for the discharge of gas or the sale of gas. And it's to the point where the gas may make up your ability to either have a well-being pay status or not pay status, basically. And it's kind of tough in those situations where the operators have full control of that and the non-operator has no control of that. So those are the items that I just want to kind of point out. And they were obvious things to look at. So I appreciate it. Thank you.
Thank you, Mr. Furlong. Mr. Wixom?
Hello, everybody. Brian Wixom.
And where you live, Mr.?
I live here in Salt Lake City, Utah, and I've been a owner of International Petroleum, a part owner, and we've been in the same office for 30 years, and I've been in the oil business for 32 years. So thanks for having us up here today. We really appreciate it, and happy Thanksgiving in advance. But anyway, I think these guys hit some great points, and and being in the oil and gas business, especially as a small family company, I mean, it's hard enough to make money as it is, but when you come up to situations like this where rules could be set into motion and into place where it only benefits the big oil companies, the 3 or 4 big oil companies, and they make profit centers in Article 16 where they charge for water disposal, coming in, going out, the gas fees, all that stuff. I mean, it could, in the state of Utah alone, over the life of the wells, it could be billions of dollars in expenses that could be passed down to the small non-operators and the mineral owners. It could, this could make the competition in the state for minerals, it could diminish that and make the value a lot less than it would be if you just had a fair deal. And I think it's very, very, very simple. If you guys would just hear with me on this, is in the oil and gas business, the operators, in 30 years, we've participated in hundreds of wells, and they usually have a fiduciary responsibility to their working interest partners to make sure that they're doing the right thing for everybody. We're in the business to make money together. It's not about, if the operator makes money and everybody else gets slaughtered. So I would say this. It is very, very simple. If you would just simply make it where there's no profit centers, you take out the Article 16, everyone is in on a cost basis. This would make everyone honest. It would be fair, and it would take care of all the problems. It would protect correlative rights. It would keep the values up. It would keep competition going and the entrepreneurial spirit that, companies would want to go out there and try to get in the oil business. If you do it the other way, it's really hard for people to get in the business, and everyone's going to steer clear of Utah if you have those really bad, costs, because the economics just aren't there. So it's really what I wanted to say today, is that I would encourage you to choose the path that would protect the correlative rights, the small independents, and all the other people. And if everybody's in on the same basis, if it's a fair deal, I think it's going to be a great time in this state to develop reserves honestly and economically. So that's what I have to say.
Thank you, Mr. Wixom. Just a few words in closing. One thing that's been a recurring theme has been, I'm sorry.
Tony, before you finish.
Yes, ma'am.
There are several signers to this matter.
Yes, ma'am.
Brian, do you represent everyone named Wixom in this filing?
No.
So there's Troy Wixom, Brad Wixom, Mark Wixom, Brian Wixom, Nathan Wixom.
Those are brothers and sisters.
Do you represent all of them?
I'm speaking on behalf right now of myself.
yourself.
And
Tony, are any of these other people here, and are they intending to speak?
They are here. If you would like to ask them questions or if you'd like them to speak, I'm sure they can come up and say a few words, but they hadn't planned on it.
I just wanted to give them the opportunity to speak, not necessarily ask them to speak.
I believe that's a round of no's, but they appreciate the opportunity.
Thank you.
Let me, are you through, Mr. Wixom?
yeah, but now you said that, could I say one last thing?
Please do.
Okay, this is a big point I wanted to say. When you frack a well, well, number one, we don't mind signing a joint operating agreement. I mean, we're going into these wells like with Axia and different companies. The well cost is $10 million. So we don't mind paying the extra cost to put in saltwater disposal, gas transportation, et cetera. And so we don't mind signing a JOA that's fair as long as you pay your share of the expenses, your fair share, and then you get the benefit and the economic use out of it. In the oil and gas business, when you have water, it can make the wells uneconomical. So you have to go in and put the money into a well, saltwater lines. You have to put pipelines in for the gas, and we don't mind paying that cost. But here's what I wanted to say. When you frack a well, for an example, in the Axia area, it's 300,000 to 400,000 barrels of water to frack the well. So this needs to be verified, but if they're charging $2 a barrel, that's 600 to 800,000 per well. Okay, now if the part that comes out, you know, they put it in on a frack and then some comes out, and if you get charged for disposal, that's extra money as well. And some of the wells that we've been involved in are 900 barrels a day of water. So at $2 a barrel, how much is that? It's $18,000 a day, $54,000 a month, $600,000 a year. That's one well. So you look at the cost on this, it's $1, $2, $3 million in potential cost on saltwater disposal per well. And if there's 40 wells in a DSU, I mean, that could be 40, 80, $120 million over the life of the deal. And if there's 50 drilling units, I mean, just imagine the type of money that's out there. So that's why it's so important to let everybody be in at cost. Everybody pays their share of the facilities. We all have, as you guys say, skin in the game, and we all benefit from the facilities. And I just wanted to point that out, that it's very, very expensive. One other thing, in certain areas, it's $2.60, $2.70 per 1,000 cubic feet on the gas. And if you look at the EUR, the ultimate recovery out there, sometimes it's 25 to 30% of the reserves on some of the exhibits that they presented before you guys. So just imagine if you're getting clobbered on the gas, that could really affect your economics going forward on the gas as well. So anyway, yeah, I'm done now.
Thank you very much.
Thank you.
Real quickly, we've talked about over this process about the standard JOA idea, and as I think is what we've pointed out here is that there is no standard JOA because these terms in Article 16 are all over the place. And if the board is going to impose a JOA on a non-operated interest, or I guess I'm not sure if you're going to impose it on mineral owners too. I guess they will, but then some of those things will need to be tightened, obviously, because otherwise, if the operator proposes the JOA and it has no standards set by the board, then obviously these are the things that are going to happen, the exact things that Mr. Wixom and I have spoke to. So we would hope you take that in consideration, obviously, because we've seen, you guys have seen them here, I would think, too. The JOAs are all over the place. There is no such thing as a standard JOA as far as we've seen. So appreciate it. Thank you.
Thank you. Just for the record, we're going to invite Troy Wixom, Brad Wixom, Mark Wixom, Brian Wixom, Natalie Lance, Lynn Wood, Reed Lambert, Cruz Kemp, and Sarah Kaya Giltner to come and speak if they're present. Seeing none, then we'll go to the second part of this, which is the division.
Just a brief closing statement, Mr. Chairman, if that's
I
all right.
beg your
before we turn-
pardon, yes. Division, why don't you come up while you make your closing statement?
Just a brief sum up of my presentation and the statements you heard from Mr. Wixom and Mr. Furlong. A lot of the talk has been about skin in the game. Mr. McDonald's referred to that repeatedly throughout the course of the Furlong case. The gaming the system concept has been discussed as well. The system is what we make it. It's what this board makes it. The system is the rules the legislature sets out. It's the Constitution of the United States, the Constitution of Utah. That is the system. The rules of the game are what the board has authority to determine underneath that precedence, underneath the constitutions, underneath the statutes. So the rulemaking authority of the game that we're going to be playing, it's not a game though. I like games. My laptop on the front here says Republic of Gamers. I've been playing video games since college. I love them. This is not a game. This is livelihoods of small businesses. This is mom and pop mineral owners throughout the basin. These are people who have no idea what they are getting when they get the request for agency action in the mail. They don't know who to turn to. It goes in the pile of scary things that they don't want to talk about or deal with. And so to the extent that this board has the opportunity to make the rules of the game, which it is not, fair and reasonable for the people that are on the upper end of the spectrum who can afford good legal analysis, the big operators, the small operators who are willing to take on big fights, of which there are not many, and make it fair for them as well as for the people that look at that brown manila envelope and go, oh my God, what have I done? It's got to be fair for both ends of that spectrum and everyone in between. And to the extent that the rules tip the balance in favor of an operator, as Mr. McKechnie in his comment letter said, pushing the envelope just a little bit. I'm paraphrasing, I don't think I have that quote right, but pushing the envelope a little bit to see what they can get away with. If nobody complains, the JOA goes through. If no one shows up, these affiliate relationships, these highly extractive clauses go through. And no one's the wiser. These things happen and no one knows. So I don't represent those people. There are multitudes. I have not been engaged by them, but Mr. Wixom and Mr. Furlong have been kind of carrying that torch for a long time now. And so you have to kind of think of them as the vanguard for all those literally thousands of people who have no idea how the decisions you guys make today will affect them in years to come. And with that, I'll turn it over to Mr. Baza.
Thank you much, Mr. Hunter. Mr. Baza.
Thank you, Mr. Chairman and members of the board. My name is John Baza. I'm the director of the Division of Oil, Gas, and Mining, and it is in that capacity that I'm commenting to you today. In accordance with the order that you provided, you have asked that the division have the opportunity to present any material or substantive alternatives to the proposed rules based on legal or factual rationale. The information that Mr. Hunter has presented today and the information that was presented as of last Wednesday on the 20th, we need to absorb, obviously, to be able to understand the impact of that on the proposed rules. I was prepared to say to you that when I appeared in front of you on September 25th in recommending to you that we move ahead with formal rulemaking, that we were comfortable with the state of the rules as they were. And I think I could say the same thing today, except that we haven't had the opportunity to really digest the comments from last Wednesday or those that we've heard today. So I would kind of reserve the abilities that the division has to say that before the final comment period is over on this rulemaking, the division would be very willing to supply you with some comments or statements related to what we've heard today, but I'm not prepared at this time to indicate that we have anything more than what we gave you on September 25th.
Thank you. And I'm interpreting that as being 5 p.m. on December 11th is the end of the comment period. Is that your understanding?
Yes, but we'll certainly organize ourselves to provide a complete compendium of any comments that we have before that time.
Thank you, Mr. Bozza. Okay, then next, let's make sure I'm correct here. The board will now receive public comment by any interested party wishing to respond to the identified interested individuals' proposed revisions and or the division's proposed alternatives. As I understand, the board or the division is, at one point in time, they were comfortable with the proposed rule and recommending going forward with formal rulemaking, but they reserve the right to make additional comments. So if you want to respond to that. So I'll turn to board members. If it's okay with you, we'll turn to Mr. McDonald.
Thank you, Mr. Chairman. Again, I'm on behalf of the Utah Petroleum Association and EP Energy. Our presentation today will be first Ms. Ricky Harenko Browning from the president of the Utah Petroleum Association will make a statement. Then we'll have testimony from Ms. Roxanne Eveland, who's with Encana, and then testimony from Mr. Michael Walcher from EP via the electronic means, Skype. And then I'll follow up with some closing comments and trying to address some of the legal issues raised by Mr. Hunter.
Proceed.
Thank you for the opportunity to address you today. My name is Ricky Harenko Browning, and I am president of the Utah Petroleum Association. UPA, on behalf of our members, timely submitted a letter on the 18th. That letter represents some concerns that we have with the proposal that you are evaluating today and represents the vast majority of UPA's members. Those members are small to mid to large size producers that sit on both sides of the operator and non-operator position. In that submission, we've provided a red line draft for consideration that supports the concerns that we're going to raise to you today. And I want to be respectful of the instruction provided by the board and your time, so we're not going to provide a full rebuttal of Mr. Hunter's comments and his view of our position. I think that Mr. McDonald may have a few key points that he wants to follow up on, but we want to focus on one key issue, which was the change in the rule just prior to the approval to move forward with formal rulemaking that requires operators to also provide funding into escrow. As far as we are aware, there's no other state that requires this double payment mechanism, which is what we see will be the result of the requirement for operators to pay into escrow. We have a few operators who are going to be testifying here today as to the impact that that would make to their future planned investments into the state and to address the concept of fairness, which rightfully has been raised in front of this board throughout these discussions. We believe that the escrow requirement for non-operators solves a very real concern that has been raised throughout this process of protecting their capital while that JOA is being disputed and dealt with. We don't think that requiring the operator to put funding into escrow solves a similar problem. The operator is already paying out a significant amount of funding in order to prepare and develop the well. Requiring operators to pay into escrow is a very real disincentive to production and stands as a likelihood of moving investment out of the state, as you're going to hear from them today. As this board knows well, there are already significant hurdles to producing in the state of Utah. The waxy nature of our crude, limited transportation infrastructure, air quality challenges in the basin, which are now going to make production more complicated, more risky, and more expensive. So we have very real concerns that forcing operators to put funds into escrow is yet a significant additional cost of doing business in the state that makes economics more favorable for locations outside of the state. We agree that this isn't a game. Keeping production in Utah is extremely important to our local communities. Our industry provides about $30 million just last year in severance tax, which goes to support the general fund alone. About $33 million to our local education system through SITLA funding, the largest single source of funding for SITLA. It's not a game. It is very important to our local economy that we are able to have a thriving and robust oil and gas industry in the state of Utah, and that we don't make the playing field harder or more burdensome in the state as compared to other places where capital can be deployed. So with that, just setting the stage, I want to turn my time over to two of our operators that we have here today to testify, to provide some color to that point of view.
Proceed.
Good afternoon. My name is Roxanne Eveland, and I'm here representing Encana and its subsidiary Newfield Production Company. And I'm here this afternoon to give you the perspective from the operator side. And really just two key points that I think are very, very important to Encana, but I believe the other operators in UPA. And that is number one, the reasons why operators are requesting that a non-operator owner that desires to participate but challenges the proposed JOA be required to pay its share of costs upfront. And number two, the reasons why the proposed reciprocal obligation of the operator to put their share in escrow is not only unfair, it's unreasonable, and it would be a deterrent to development in the state of Utah. So just to hit on the reasons the operators are requesting the non-operator put their share of cost in escrow up front. And I want to start by just, my idea of where this scenario plays out is, in very simplistic terms, is an operator sends out a well proposal, AFE, and JOA. A non-operator communicates back to the operator, we want to participate in your well, but we have some issues with your JOA. The operator and non-operator, endeavor to work through those issues. Those issues can't be worked out, and one of the parties ends up saying, we're going to go to the board. This is, the non-operator is wanting to still preserve their right to participate. And so the way I see it is that if the non-operator puts up their share of the cost of capital up front, that is preserving the right to participate, just the way that every other owner that has voluntarily signed a JOA has done. So kind of in support of that, the first thing I want to touch on are the numerous pre-drilling costs that are already incurred at the time the well is proposed. In reality, all of the title, the payment to the surface owner for the location, the pipeline right-of-ways, the road access, surveying, plats, permitting, which is state and federal, and oftentimes with federal permitting you have some pretty costly, ARC, paleo, and additional things that you need to do, building the location, and things like that. A lot of that work is already done by the time the well is proposed. That's pre-drilling. Typically, an operator is going to propose a well 30 to 60 days before the well is spud. So a giant part of that cost has already been incurred. I would say on the average, it ranges from probably $200,000 to $400,000 of just the pre-drilling cost. But another thing I would like you to consider is that in all likelihood, I think we know that if anytime that there's a negotiation process going on between the non-operator and the operator, it's probably going to take a lot longer than that time period between when the well gets proposed and when that well spuds. And really when the well reaches TD. In other words, the operator's not going to wait for the outcome of that hearing. The operator's going to be continuing to drill the well. So in all likelihood, the well could be spud and drilled to total depth by the time all of this has been resolved. Now you're looking at, in the range of $2 to $3 million of dry hole cost that have been incurred at this time. That's about a third of the cost of the drilling and completion cost of the well. And, I would take it even further to say there's a possibility, if it drags out even longer, that the well could be completed by the time that all of this is resolved. Now you're talking about completed well cost of $7 to $9 million. And keep in mind, this means that the non-operator that says, I want to participate, but I am challenging some of the provisions of the JOA, they haven't had to pay anything. I mean, how is that fair to the operator? How is that fair to all of the other non-operators that are under JOA and have already signed that? And another thing you need to think about, I feel like it's been downplayed a little bit, but this gives the non-operator a risk-free look at the drilling and possibly completion results. I think it would probably be rebutted that, well, if you're not receiving the drilling reports, or you're not, receiving this or that. The reality is, at least in the Uinta Basin, people talk. So to say that they're not going to know, how the drilling of the well has been going, how the completion of the well went, I would say in reality they would absolutely know. And this is something that we refer to as getting a smart look, right? And the operator doesn't have that opportunity. The other non-operators that have participated don't get that opportunity. And the real concern here is if the non-operator has paid no cost up front, what keeps them from changing their mind and non-consenting the well? If they know the well results and it finally gets to, to the board and a JOA is decided upon, what keeps them from just non-consenting or even not even getting to the board? What if they already know what the well results are and they say, gosh, there were some issues with drilling that well, so you know what, we're just going to non-consent. So, I think the skin in the game has taken on a life of its own over this proceeding, but I think when it was first used, it was just really meant to say, if you are truly saying, I'm preserving my right to participate, the cost of the cost, and I agree with that, and I agree to participate, and I agree that we're going to sign a JOA, we just need to work out the terms. Why is it not fair to pay your share of those costs up front? The operator's paying their share, the other non-operators are paying their share. Which kind of leads me to my second major point, which are the reasons the proposed reciprocal obligation of the operator to put its share of the cost in escrow are, not only unfair, they're unreasonable, and they would be a deterrent to development in the state of Utah. The reality is the operators already pay for 100% of the cost up front. For the non-operators that are under a JOA, the operator can either bill them for their share of the cost under the monthly joint interest billing, or the operator also has the opportunity to basically cash call for the next 30 days worth of expenses, okay? But the operator is still paying all of those costs up front. The vendors have to be paid regardless. So all of those pre-drill costs, as we talked about, most of them have already been paid by the time the proposal goes out. If now we're into drilling, all of the costs that are associated with drilling are being paid by the operator. You certainly don't get the luxury of going to your drilling company and saying, well, we're having a disagreement with a non-operator and we've had to put our share of operating costs in an escrow account, so we're not going to pay you until it's resolved. Certainly you don't have that luxury. And requiring the operator to put its share in escrow, it effectively requires the operator to put up its share twice, right? We're paying the bills, we're paying the vendors, and now we have to put our share in an escrow account. I mean, I think you've heard us refer to this as double dipping, but just from a mathematically, think about it this way. If you're talking about the $2 million dry hole cost of a well and an operator owns 90% of that well, then not only have they paid out $1.8 million its share is $1.8 million. Now they're going to have to put $1.8 million in escrow. And, you know, Mr. Hunter had suggested in his letter to the board that that money remain in escrow until the well is completed or a board-ordered JOA is in place. So that's not even saying that as costs are incurred, you can start to take some of that money out of escrow. That's true double dipping. That is requiring the operator to pay their bills, but also put their proportionate share in an escrow account. You know, one other note is that, again, the other non-consenting owners who have signed a JOA, I mean, they're not going to be required to put their proportionate share in escrow, and rightly so. But again, this is making the operator the only party that's paying twice. Another key thing, and I think this is something that hasn't come up yet, but I think this is probably one of the more important driving forces behind the operator position, and that is capital budgets. Whether you are a privately held company or a public company or a company backed by private equity and you are an operator, you know, you go out and you work on your drill plan and you get advanced approval of your budget. So for instance, I'll use Encana. For 2020, the budget for the whole company starts in August of 2019. Like, that's when you start budgeting for the next year. And all of those budgets are based on your estimated share of the cost of wells, okay? So when a company sets their budget for the next year, they're not saying it's budgeted at 100% of the cost of the well. It's budgeted at your proportionate share of the cost of the well, because that's what you're ultimately going to pay out. So I feel like it leaves operators in this position that if there's an obligation to put its share of cost in an escrow account, now you're going to have to make this choice. Do you risk going over budget because you've had a protest? In other words, you keep budgeting the way you normally would, but if you have a protest, you know, that could put you over budget because you've had to take capital dollars and put them in an escrow account. Or do you have to start estimating, like, how many people are going to protest and start budgeting accordingly? And, you know, that's not going to be very favorable either, because I can promise you the budget doesn't get bigger. The companies are just forced to try to do more with the same amount of money. So if those operators are going to have to budget for that amount that's going to go into escrow, that's dollars that are being put into an escrow account instead of being put into the drill bit and drilling wells. You know, and to further that, you have to think about it. There's many operators that have multiple rigs and or are drilling multi-well pads. So conceivably, you could have multiple protests at once. So, you know, like I said, operators' share of $2 to $3 million of dry hole cost over multiple wells, I mean, that could certainly be very problematic towards budgeting. Just to kind of conclude my remarks for today, just, you know, something I think it's been said before, but I'd like to reiterate it, which is most of the operators are also in a non-operated position. Encana has acreage in, you know, 3 or 4 other operators' areas. And an operator is not going to request anything that it would be opposed to when it's on the non-operator side. So that goes towards the JOA provisions that have been talked about a lot here, the Article 16 provisions, and that goes to the rules that we're talking about today for forced pooling. You know, we have to live with these rules and those provisions on the non-operator side as well. And really the point I think I want to make the most to this board, and I really want to stress, is that, you know, if this were to become part of the forced pooling rule, that an operator had to put their share in escrow, that unprecedented requirement, it will be a deterrent to dedicating capital to the state, to Utah assets. For a company like Encana that has many assets in their portfolio, it's going to be a deterrent, and, you know, it's going to make a company think, gosh, we've got these other assets that don't come with the same risk, that don't come with the same uncertainty. We're more comfortable allocating our capital to those assets. And so I just want to make sure that, that point is understood, that, as it was mentioned before, that there's a lot of hurdles to operating in Utah that, all of us deal with every day. And just one more hurdle, risk, uncertainty could certainly make it a less valuable asset in a portfolio.
Next.
Paul, are we set with Mr. Walcher? Yes. Okay. Next will be Mr. Walcher from EP, who'll be testifying electronically. Go ahead, Mike.
Hello? Yes. Yes, my name is Mike Walcher. I'm a land advisor with EP Energy, EMP company. First of all, I want to thank the board for allowing me to participate remotely today in order to provide this testimony on behalf of EP Energy. What I'd like to do is put some additional color around Ms. Evelyn's testimony by presenting some information to the board about EP Energy's costs of drilling and development, when those dollars are spent, and why it's just and reasonable to expect a non-operator who wants to participate but also wants to object to the terms of the JOA to escrow its working interest share of funds. But on the other hand, it is not just and reasonable to expect the operator to also escrow its much larger share of development costs while those JOA terms are being debated. Can you show the first slide, Fred?
It's up on the presentation. Does the board have that on their screen?
Okay.
Yes.
Okay, now I can see it. So the first slide shows the representative costs of a multi-well drilling operation with 3 long lateral horizontal wells that are drilled consecutively from a single surface drill site. So as you know, over the past 2 years, EP Energy has transitioned from a vertical to a long lateral horizontal development program in the Altamont field. We're drilling 2 to 3 well bores consecutively from a single surface drill site in order to maximize the efficiencies of scale. So we save money on surface locations, we save money on rig mobilization, and we save money on frac costs by drilling wells consecutively from a single pad. But as you can also see, drilling these wells is very expensive, a very expensive proposition. And since EP Energy has 2 rigs running currently, we're incurring 2 times these costs at any one time, roughly about every 4 months or so. It takes about 4 months to drill these wells to TD, 3 wells to TD. The first thing I want to point out is that the caveat that these are representative costs for a 3-well drilling operation. It's in the shallower part of the field. These costs, they can and do rise dramatically by millions of dollars in the deeper parts of the field, or where we have additional frac stages that we want to perform. But generally, we spend about $1.2 million in pre-spud costs, the same costs that Ms. Evelyn testified to, over about a 4 to 6 month period just to secure the APD. And then we have to prepare the surface location and set the surface casing on the 3 wells. After that point, then we bring in the drilling rig and we drill each of the 3 wells back to back, spending about $10 million in about 60 to 90 days. Then there's a gap between releasing the drilling rig and bringing in the frac crews to complete the wells. And that's because we bundle the completions and contract with frac crews to do multiple wells, completions back to back, which again saves us money. But these completions cost about $5 million per well and take about 10 to 15 days each. So we spend another $15 million dollars in about 30 to 45 days, completing the 3 wells. The whole process from APD approval to first production takes about 5 to 8 months and costs roughly $29 million. Again, that all can increase dramatically for many reasons, and we're spending those dollars on another set of wells at the same time, so it doubles. So when you talk about a little bit about timing of those expenses in relation to the well proposal and forced pooling process. So in a perfect world, we would secure the APD, then we would propose the wells, then we'd wait for everybody's election, and we'd wait up to 4 months or more for the forced pooling process to play out until we get everybody's election and everybody committed to a JOA. Then we would get everybody's working interest share of the costs, and then we would contract the rig and drill the wells. But the reality is that because we contract the rigs for periods of time covering many wells, we have to meet a drilling schedule. We cannot afford to stack rigs. So for this and other reasons, we're often receiving the final APD approval just in time to spud. Since we propose the wells when the APDs are approved, then by the time elections are in and cash calls are due, we're spudding the first well. Now, if a co-owner, and that's the best situation that we have, if a co-owner can delay their payment another several months until a forced pooling order is issued, then they will have seen all 3 wells drilled and perhaps even 1 or 2 completed before they have to pay their share of costs. In our opinion, that's not just unreasonable to the operator who has fronted, paid 100% of the cost to that point, nor is it fair to the other participating co-owners who have signed the JOA, paid their share, and assumed the drilling risk. So what we've proposed is that a co-owner who wants to dispute provisions of the JOA should pay its share of costs up front, just like any other participating co-owner signs a JOA. And in our opinion, the argument that, to be fair, the operator should also have to put up its working interest share of costs in escrow ignores the disproportionate spending by the operator and the fact that the operator is already committed to the wells, is spending millions of dollars, and is carrying the co-owner's share while the forced pooling process plays out. So the second slide shows, kind of highlights that disproportionate spend. And this is actually an actual real-time situation. So in late October, EP Energy, who owns 87% working interest, proposed 3 wells in one of these multi-well drilling operations. We're currently drilling the second well. EP Energy is paying 100% of the costs, including the other co-owners' share, until all elections are in. There are several co-owners in these wells, one of which we anticipate may dispute the JOA. That owner owns 0.25% of the working interest. So their share of the AFE dry hole cost is $27,000. Now, the question is, should EP Energy be required to escrow another $9.5 million on top of what we've already spent, which includes that co-owner's share, by the way, while that small co-owner disputes the JOA? Compounding the problem is that since we have 2 rigs running, we could have several of these disputes going on simultaneously, creating an even more untenable financial burden for EP Energy. So requiring the operator to escrow its share of costs, in our opinion, ignores the reality of how and when dollars are spent, and if implemented, would be a huge disincentive for EP Energy to drill wells in Utah. Now, requiring operators to escrow their working interest share of the cost while a small co-owner disputes the terms of the JOA will not provide fairness, but it will have a chilling effect on oil and gas development in Utah. I appreciate your time.
Can we ask the witnesses to come back up and Mr. Walter, will you please stay on the line?
Absolutely.
Mr. Hunter, yours as well, please. Before we go to legal argument, I'd like to ask just some fundamental understanding questions. And I invite, let's start with Ms. Eveland, and we'll go to go across. So the question I have, number one, is dealing with the basic overall principle that I think, and I'm speaking for myself, but I believe it's the board's direction, is that at the very front end, somehow, some way, all consenting parties be contractually bound. And that's based on the assumption that an AFE and a something short of a JOA is not a contractually bound. That is the assumption. To get that was kind of the starting point. Would you address that, Mr. McDonald, with your witnesses, and then I'll go to Mr. Hunter.
Do you want me to go ahead? And hopefully I will answer the question that you've asked there. But, you know, again, as I testified, I mean, really the premise here is that this is an instance where a non-operator has said, I want to participate. I'm going to sign a JOA. There are certain terms of this JOA that I don't agree with and I want to challenge, okay? So there's no dispute that they want to participate. There's no dispute that they want to be a party to a JOA. Anybody else that signs a JOA is paying their share of the cost. And so really that's the premise behind all of this, is that if you want to preserve your right to participate, your option to participate, then you should be bound just like anybody else that's signed the JOA, because you've basically said, I want to participate. It's not that I don't want to sign a JOA, I just don't want to sign it in the form that it's in.
Okay. And a follow-up question to that then would be kind of a other side of the coin. And the other side of the coin would be that once you are in a position of consenting, that's fixed at some point in time and can't be changed after the well information has come to that party.
Yeah, and that's correct. I mean, under a joint operating agreement, I mean, once you elect to participate, you're in. There's no change in your election.
But there are also other places in the JOA where there are elections, casing point election or others, where you can go consent or non-consent.
Typically only for vertical wells. You know, in the horizontal world that we live in now, I mean, I can speak to, in Canada's JOAs don't allow for a casing point election because they're for horizontal drilling.
Okay. But in a typical AAPL operating agreement standard form, what is the amount of time that you're given to make an election? If a rig's on location.
For a casing point election?
Any casing point would, my understanding is 48-hour work.
Yeah, that's correct. For the initial proposal, it's 30 days. But if you're talking about like the casing point election, it's 48 hours.
Okay. So, okay, I just wanted to make sure I understood that. And then I want to, let's take that same question to Mr. Hunter. Do you and your group have issues with, and this is for educational purposes, I'm not challenging you, with being fixed as a consenting owner at some point in time at the front end of the well, at least prior to where you have the well information? Do you have any objection to that?
If I understand the question correctly, you're asking if you have an issue with a non-operator defining themselves under the statute as a consenting or non-consenting owner prior to a board determination of whether they're a consenting or non-consenting owner. Is that kind of where we're going with it?
Let's just take that as the definition for now.
Okay. Speaking as the attorney for my clients, yeah. The statutory procedure is there so that the board finds facts, makes conclusions based on those facts, and applies the law to them. So the idea is that if you negotiate for contractual provisions and both parties agree to it at arm's length, you're consenting. You're in the well, as was stated. Yeah, if you sign the JOA, you're in the well. The question is whether or not the terms of the JOA as proposed are going to govern. And that we don't know until the end of the pooling hearing.
So stated another way, the way that the rules sit now, my understanding is that you would be fixed as to consenting in terms of paying for the well. You have the right to come to the board to argue about the terms of the JOA, that before you can come before the board, you have to make that election so that you're fixed in time. Is that part of your argument against what the rules currently say?
Again, I think there's two separate arguments that need to be teased out. The first one is the right to a hearing to determine the facts of whether you're consenting or non-consenting under the statute. I don't think that the way things are currently, you have manifested under the statute an agreement or a consent to participate. You are withholding consent as to the terms of that participation until the board has ruled on something, if it goes to that point.
And that's really the key to your argument, isn't it? That's the lowest common denominator of what you presented today?
I think that's a fair way to say it. If full consent, as has been discussed, is payment, agreement to the JOA, payment of a cash call, that's the best evidence of consent you could possibly have, then yes, I think that's very clear, and that's a non-operator providing the evidence that the board would need to make a finding of consenting owner unequivocally. I think not answering an election letter and not signing a JOA and not mailing a check is complete evidence that the board needs to determine someone is non-consent. I think the problem we're trying to wrestle with is that a non-operator needs the freedom to say, this is a good geological and engineering risk, and we want to take this with you as you proposed, operator. However, certain terms of your conditioned proposal make this an uneconomical or undesirable play for us, and if we can fix that, we're in. If we can't fix it, we're out, because we'd much rather just not deal with you, preserve our capital for better projects, and go on down the road.
Okay. But the current, just to make sure I understand, the current situation is that if you don't agree to pay for the well and don't sign the JOA, you're non-consent. And that's the world as we have it today.
Under the current 1.2, yes.
And so what this is doing is bifurcating the issue between consenting in the well and arguing about a JOA provision that is ancillary to drilling the well, affiliate relations, for example.
I think part of the terms of the JOA not only are going to give you the way everything's going to be operated, but there's other terms in there such as the gas there are charges for the marketing, gas takeaway. Those things are also going to come in play in a decision to be able to decide if you're going to consent or non-consent to a well, because it's going to be a part of the whole big picture, really.
That's not just engineering and geology, but it's really other factors.
It's going to be any factor that's going to be a cost in the well, so that you can determine what your return is going to be would be also involved.
Mr. Walter, I passed you over. Would you like to say anything about that question?
Well, in our opinion, if a party makes an election to participate, signs the AFE and indicates that they want to participate, but they don't like the terms, some of the terms of the JOA, and we can't resolve that, then the remedy is we go to the board and we debate the terms of the JOA, and the board makes a decision about what terms are appropriate in the JOA, and the JOA is imposed upon the co-owners. So, in my opinion, you are participating when you make that election to participate and sign the AFE, whether or not you approve or like the JOA terms, because the terms are going to be, you're going to have a JOA whether or not you approve of all the terms or not eventually.
Okay, thank you. Next question. This deals, so let's define the terms. You have the operator who has physical custody of the well and is responsible to drill the well on behalf of the other working interest owners that have consented to the drilling of the well. And then you have those that are non-consenting that have the right to receive a royalty free of costs until such time as payout occurs, and then they back into the well as a working interest owner. So the question is what's that risk allocation factor that ranges by law from 150 to 400%. So as to the operator, on a one well scenario, and it may not work for a 3 well scenario, but let's say 1 well scenario, is there a offset that the operator could take for its upfront costs that would be put in escrow regarding the amount up to and including the dry hole costs? You understand what I'm saying? So if, for example, on the exhibit that Mr. Walsh, and I hope I'm saying your name correctly, sir, is it Walcher?
Yes, sir.
Okay.
Perfect.
Let's take just for argument case, take all of the costs that go to the pre-spud cost, 1.2 million. And the dry hole cost, I'm not given on any of these exhibits. But if that 1.205 million was a deduction from anything the operator would have to put into escrow regarding the dry hole costs, that would almost always be an offset completely to your share of the dry hole costs, would it not?
So using Mr. Walcher's exhibit, so his pre-spud and drilling costs, $10,955,000, that's the dry hole cost. So I think if what you're saying in this example is, could you offset the 1.2 million from the 10.9 million? I mean, that still puts your operator putting over $8 million in escrow. Is that what you're?
That's what I wanted to understand. I thought that number was less than that. So define a dry hole cost for the board.
The dry hole costs are the costs that are incurred to drill the well to total depth.
Chairman, I understood your question to be to reduce the escrow requirement by the amount of money spent, whether it be pre-spud or dry hole cost. Is that what you were asking? Rather than requiring this double deal where you've got to escrow and
So would that just be escrowing amounts going forward? Is
Let's say you
what
had
mean, or?
I think that's what he's asking. So you don't have to escrow it if you're already spending it.
Hang on. if you've already spent it, and this is not an indicator of where I'm going to come down on this issue. I just want to make sure I'm not misunderstanding. So let's say that in a 50% working interest ownership position for the operator on the exhibit that's in front of us, just so the board understands what we're talking about, you would take the 10,955,000, divide that in half, which is about 5,495,000 or something like that, and then you would offset that by 1,200,000. So you would be putting into this roughly, somebody could do the math, but you're still putting in 4 million.
Right, right. I would say from an operator standpoint, any amount of the operator's share of any of the costs, pre-spud or dry hole cost, any amount that would have to be put in escrow would be very problematic.
Mr. Walchuk, would you respond to that? And then I'll go to
Yes.
Mr. Hunter.
Yes, I agree. The operator is already committed to spending the funds to drill and complete the wells. So we are spending the money, whether it's put in escrow or not. There's no benefit to putting money in escrow to prove something. I'm not quite sure what. Any more than we've already committed, any more than we've already proven that we're committed to this well. Adding additional costs by putting money in escrow just adds additional burden that's unnecessary. And how are you going to account for all this escrow? Who's going to account for it? Who's going to do the debits and credits to manage and administer this escrow account? It just doesn't seem practical, let alone fair.
And is it, Ms. Eveland and Mr. Walcher, is that the key thing that said that would be the disincentive for you doing work in Utah, considering everything else that we have as baggage?
Yeah, it's tying up additional capital in an escrow account. That's capital that you can't use to drill more wells. Like I said, your budgets don't get bigger. You just have to, if you're having to put dollars in escrow, you're just having to do more with the same amount of money, So mathematically, that may mean if you've got to put X number of dollars in escrow, you may be having to take a well off the end of your drilling schedule. You may have to drop a well because you don't have the budget to drill and complete a well.
Thank you. Okay, Mr. Hunter, you're the non-operator. You're a working interest owner, and you have not, as you mentioned previously, you'd like to go to a full hearing before you have your election as a consenting party, and that may be after the well is drilled. But let's just assume it's before the well is drilled. Tell me your thoughts on escrowing your share of the dry hole costs. You're going to spend them anyway if you are a consenting party. And by consenting party, so there's no question about it, as I'm defining a consenting party for the purposes of this discussion today, I'm talking about someone who's contractually bound, whether it's by a JOA or that you could be sued, that you have done something, whether it's a letter that says we are consenting, that you are in fact contractually bound under Utah law. Okay, assuming that's the starting point, tell us about the escrowing the funds.
I think that if we start by assuming, like under the unitization statute, that a unit plan contractually binds somebody to do it, then I think a dry hole type cost or the similarity to an election point of a casing point, because remember this rule has to work for everybody, vertical wells, horizontal wells, all it has to work everywhere and always, might be appropriate. But the beginning of the question, the premise of the question is that there's a contract. And under the statute, the pooling statute, there's no relationship until the pooling order has been entered. So I understand the purposes of discussion, what that is, but then you're talking about literally a JOA, or you're talking about underneath a unitization statute where there's a unit operating agreement that's been imposed by the board order. So I mean, to get to a contractual point, there either has to be assent, arm's length, meeting of the minds, all that good stuff we learn in law school, or to get to consenting owner definition under the statute, there's got to be a board hearing. There's got to be a final order. So I think that having an escrow is fine, but then you're just under a JOA, where you have got the cash call provision under Article 6. I don't remember the exact article. But you've got the cash call provision, as was testified, you can get 30 days in advance.
Okay. Next question. Ms. Eveland and Mr. Walcher, affiliate relations. There may be affiliate relations, there may not. But if there is affiliate relations, what is done now about disclosing those relationships?
As far as affiliate relations, I mean, this is the first I've heard that this is an issue. So I'm not prepared to talk about, this could go down a huge rabbit hole. And I'm not prepared to talk about the different affiliate relations. I guess one thing I can talk about that's come up, like for instance, with the gathering lines, there's talk about, who owns the gathering lines? If the operator owns the gathering lines, whether or not, is it fair to charge a fee? And I guess the point I would make is, if they're charging a fee and they're jibbing the cost of the line to the partnership, yeah, that's not okay. That's double dipping your partnership. But in like the instance of Encana, we own gathering lines and we charge a fee. We just happen to own the gathering line. Somebody else could own the gathering line. If somebody else owned the gathering line, they would charge a fee. And the other thing to remember is when that fee is charged, it is charged to the working interest owners at their proportionate working interest. In other words, if we own 90% of the working interest in the well, we're really only charging out 10% of that fee, right? We're charging it against ourselves. It's not like we take ourselves out of the equation and then spread that across the rest of the working interest owners. So that's something I feel like I want to make a point about. But as far as getting into the nitty gritty details of the affiliate relationships, and like I said, it's a pretty big rabbit hole that we could go down. I'm not prepared to speak to that today.
Mr. Walsher?
I would have to agree. EP Energy, in my understanding, we don't have any affiliate relationships like they are concerned about. We do own gathering lines. We do charge a fee for those, but again, we are burdened with that fee as well on our economics. But we're not hiding any cost centers through affiliates somehow in some manner.
Now talk about a joint interest audit. The non-operators, the co-working interest owners, consenting parties, have the right to come in and do a joint interest audit. Tell us about that and how often it occurs.
So a joint interest audit is allowed under the terms of the joint operating agreement. It does allow the non-operators to come in and look at your accounting, to see how you're accounting for things, both on the joint interest billing side and on the revenue disbursement side. As far as how often it happens, I'm not going to say it's unusual. Does it happen? Are we under nonstop audits? No. But I would say probably in 12 years of working the Uinta Basin, that I'm aware of, probably all of our, 3 to 4 of our major partners have probably audited us at least once during that time. So it's not unusual. There's different reasons to do an audit. But it's not unusual, but I wouldn't say it's something that happens every day. but it's certainly, it's within the rights of a non-operator under the JOA.
And then, so in terms of your understanding, the joint interest billing, the operating agreement that has attempted to be a standard form, the one you send out as operator to the non-operators, you understand, they understand by the joint interest audits, to the point that when now you're a non-operator in the adjoining well in another spacing, or adjacent well in another spacing unit, and you get the same JOA back. How does that work in the industry, common industry practice?
I mean, I would say common industry practice, and I'm going to use EP Energy as an example because Encana does have leasehold within EP Energy acreage, operated acreage, and EP Energy previously held leasehold within Newfield operated acreage. And so how it worked was our two companies negotiated a JOA together. And so there was one JOA that for our operated area, we were the operator. For EP Energy operated area, they were the operator. But the terms were the same because we're going to be an operator on one end, non-operator on the other side, and we've, you've got to live with what you put in there as a non-operator, or obligations of the operator, rights of the non-operator, and both parties have to live with that, especially if they know that there's that same relationship. And so that's what we've done with EP Energy and some of our other operators in the Ueno Basin that we own leasehold acreage in their operated position, and vice versa.
My understanding you to say that generally the operating agreement you offer to others, you should be willing to receive back when you're the non-operator.
Yes, absolutely.
Mr. Walcher?
Yes, I agree.
Okay. And then there's been examples today of egregious costs. Would those costs be discovered by a non-operator in an audit?
Yes, if a non-operator were to audit, that's certainly, I think some of the things that have been talked about are water disposal, gas gathering, all of that could be subject to a joint interest audit.
Okay. Mr. Walcher, and then I'm going to go to you, Mr. Hunter.
I don't have anything to add. I agree with everything Evelyn said.
Mr. Hunter, the question to you then is, and your group, if an other non-operator, Savvy company, has accepted the terms of a JOA on a generic basis, no side deals, what costs are you talking about that your clients and your experience have shown that would be unfair in relationship to your group as compared to other consenting non-operators?
I believe the threshold question is, what is the definition of materially and substantially? Those words interchangeably have been thrown out since the 2015 hearing with EP Energy. What is a materially similar or identical JOA and substantially similar JOA? The threshold question is, would those non-operators be willing to file their similar mirror image JOAs with the board and testify under oath that this is the deal between Encana and EPE, between Finley and
It's just using Encana and EP today because they're here. And they could respond to it. So let's say that EP is the non-operator and they have signed the JOA that has the particular provisions. What other provisions in your experience does the board not understand in terms of egregious costs or things that would be in the JOA that would be offensive to you and your group?
Certainly. Assuming as a threshold question that we'd get witnesses under oath to testify that this is the deal, the whole deal, and nothing but the deal, starting from there, we need to turn to another term that's been used ambiguously and interchangeably, fees and costs. The statute lets you recover costs. It doesn't let you charge fees. And it may seem like a distinction without a difference. I get a couple of squinty eyebrows here, but this is what Mr. Furlong was talking about earlier. If he sold water to an operator for 30 cents a barrel, that's the operator's costs for the water. If he gets a joint interest billing that has a fee of 80 cents a barrel from the operator he just sold water to for 30 cents a barrel, that's not costs, that's a fee. And that's not allowed under the statute because you're supposed to recover the drilling and operating costs. And that's where I think it's a little disingenuous to say that, well, we charge ourselves the same amounts. You charge yourself a fee and then you write it off in other ways. It's not costs.
Hey, let me ask you this question. In a previous case that we had that went to the Supreme Court, a non-operator, non-consenting party who was yet to consent objected to the JOA because they wanted the operator to pay their royalties. And the operator was not in a contractual arrangement with either the company or wasn't in a contractual relationship under the oil and gas lease. And the royalties we're talking about is the landowner royalty. Tell me about that, how that fits into your arguments. I've never seen it in a JOA. It may be, but only if it's.
I just want to clarify a couple of things. One is that we did consent to the drilling and operating. So we just were not offered the JOA at that time. So we struck the sentence that said, you consent to us drilling and operating and then subject to the JOA. Well, we struck that, so that's what started the non-consent hearing. It wasn't because we didn't agree to let them drill and operate. It's just we didn't have the JOA in place at that time, or nor had we seen it. And actually, we didn't receive it till several months later to make the determination whether the JOA terms were acceptable to us or not. So what we looked at was the AFE. The AFE has its drilling and completion costs. That's fine. We can make one determination there, but when you have these other terms of a JOA, we might not like those terms of the JOA, and we either can negotiate them out or we may go non-consent just based upon that because the operator's conditions that they lay out in the JOA. And so I just want to clarify that firstly.
Thank you.
To answer the chairman's question, this is again a question of information. The operator possesses all of it. The non-operator possesses none. These fees and costs, depending if we use those interchangeably or not, the operator's in full possession of what's being charged to transport, dehydrate, compress, et cetera, et cetera. We're talking about gas. Other expenses were on the oil side as well. As a non-operator, we have no idea if those are being properly deducted. We have no idea if they're being properly charged. We have no idea if there's affiliate relationships or other things. The operator's in possession.
Doesn't all of that come up in a joint interest audit?
And
rather than in the contractual stage?
That's an excellent point, because what we're talking about here is now at least another step down the road, because what we're talking about is a proposed rule that says if you want to argue about the JOA, you need to tender your costs first. You need to tender your AFE costs first, whether it's dry hole or full completion costs. Now, what I understand is we also are going to pay for a joint interest audit on top of that to make sure that the agreement we didn't like in the first place is being operated in an equitable manner. So this is yet another burden that you're putting on the non-operator to ensure that the information that we lack in the first place to make a decision is the correct one.
Even if we did nothing today, if we canceled this and took where we are today, the starting point, you would still have the risk of a joint interest audit if you had a question about how things are billing. Is that correct?
The difference is we can go non-consent, and then the landowner gets the royalty, and the operator's going to have to pay for it. It's in the statute. And we can control our capital costs, we can control our time and energy and go, as has been said over and over again, we can seek greener pastures, not
But
in
you also have the right to receive a royalty. You're not, when you're non-consent.
if you're a working interest owner.
You're working, you have a chance to be compensated for that.
Not as a working interest owner. It's the mineral owner that gets the baseline royalty. The working interest owner who owns the lease, but not the underlying minerals, gets nothing.
Yeah, that's correct. I misspoke. Okay, I think that gets me to where I want to make sure the landscape. I do have a couple of questions for you, Mr. McDonald, when we get to that point, but let's do this. Will you then, where are you in your presentation?
We have one more witness, Mitch Mayo is an attorney. He's been in front of the board, and he's also representing Altamont Energy. He would like to make a statement.
Mr. Mayo, please come forward. Mr. Mayo, proceed.
Chairman, members of the board, I appreciate it. As Fred mentioned, I'm here on behalf of Altamont Energy Operating LLC. We're just an interested party who would also like to comment. I appreciate this very thorough discussion. It's obviously been months of a very thorough discussion, and what Altamont would like to say is simply to echo some of the concerns that were raised by Ms. Evelyn and Mr. Walcher regarding the escrow contributions. Altamont Energy is a fairly new company to the basin, as the board is well aware. We've been in, I believe, 3 times this year to see the board, and hopefully again in a couple weeks, a 4th time to see the board about setting up operations as Altamont gets its feet under it to begin.
You're a startup. Can you consider yourself a small operator, a medium size?
I mean, I think size-wise, capital-wise, definitely Altamont's a small operator for the basin. I don't know how anyone else here would categorize them, or whether Altamont themselves would agree with that, but they do have a fairly small acreage position, and capital is limited. What's interesting about Altamont's perspective, and maybe helpful in this, is, Encana and Newfield, they're established. EP's established. They've been here for years. They know the cost. They know the drilling. And they've presumably got their funding set up, and it's a matter of setting budgets and meeting budgets and going through the process. Altamont is slightly different, and they're a lot like some of the companies who are looking to either come into the basin or looking to invest in the companies that are in the basin. Altamont is private equity backed, and so what that means is essentially Altamont has spent about a year and a half now getting their feet under them, establishing their position, recompleting several wells to increase production and get cash flow positive. They've done the work, as Mr. Hunter pointed out, the first steps of getting the field spaced the way that they see drilling being dependent. They've gone out and done that based on geology, and with this board's blessing, they've spaced it, and they're setting themselves up to begin their drilling program in earnest in 2020. They've gone through the permitting process for several of those wells. And so what Altamont is in the process of doing now is raising capital. Altamont's not a publicly traded company. They have to go out and they have to fund their operations. And so Altamont's in a position where they're asking people to give them millions of dollars to continue this drilling program. And at the same time, they may have to say to them, but there's a portion of your money that you may get zero return on. You should still invest with us, but you should know that we may just put a portion of your money in escrow for some time. We don't know how much, we don't know for how long, and we don't know how many of our wells we'll have to do that on. But you should invest in this because we can give you this rate of return. And I think it's important to remember that operators, non-operators, size, lack of size, if you believe Mr. Hunter's position in this hearing, I think a lot of it is that the board is rapidly careening down the hill in an industry-driven bus that's going to go off a cliff and take all the mom-and-pop operators, non-operators, small mineral owners with them. just so the companies can line their pockets. And I think that's obviously a very incorrect assumption. This board has been around for years. This board knows what they're doing. They've got the ability to adjudge cases on a case-by-case basis. And every single one of the concerns that Mr. Hunter has raised, without going through them point by point, there is a statutory or a regulatory mechanism for everyone to have a say. And so it's important to remember that the board is not today making a decision that is make or break in any sense. What I fear is that there is a decision made today based on the fear that has been stoked into this hearing, rather than the actual changes that are being made. We're talking about how someone is non-consent. And we can, as lawyers, we make a living on parsing the word consent. Has someone consented? Have they not? We all know that if we were selling our house and someone said, I agree to buy your house, we wouldn't take it off the market until they'd signed some paperwork that said, I promise I'm going to buy your house, or else you get something from me. And so I think we have to really think about the rules. And what Altamont wants to say is, we're supportive. We appreciate UPA's efforts. We appreciate Mr. Hunter and the non-operators for participating in this process. We also want to remind the board, as a lot of people have today, and that's that the legislature makes the laws. The legislature passed a statute, and it said, a pooling order shall apply to future wells. That's not something this board has the authority to change. This is a fact of life for everyone in this room going forward. What we're trying to do is implement rules that make that equitable for all sides. And so Altamont just wants to say we appreciate the opportunity to speak and to echo the concerns that this escrow requirement, aside from being a budgeting nightmare, is something that may well make it difficult, if not impossible, to raise funds to implement Altamont's drilling schedule as planned.
Thank you. Board members, I don't know the right time to ask you to ask your questions. Maybe right now, but Mr. McDonald, in deference to your time, let's go to you next, and then for your statements, and then I've got a question for you, and then I'll let the board members ask questions until you have to leave.
Thank you. Fred McDonald.
Let me ask you one more question. If we took a break at 2:30, for say 10 or 15 minutes, would that give you time to complete?
Probably need to make it at 2:25.
25? Okay. We plan to take a break at 2:25, just to give the board some time to just a break.
Okay. All right. Fred McDonald, again, legal counsel for UPA and for EP Energy in this matter. I think the points have been made as far as that the real problem right now with the new rule is the reciprocity issue. The other comments were made in the November 18th. My focus is going to be trying to address some of the concerns that Mr. Hunter has raised. I'm not a constitutional specialist, but it seems to me that it boils down to due process. And in each and every step along the way, there is due process. Let's start with the fact that you start with a spacing order. Under the Cowling case, you can only force pool if you have a spacing order in place. So there has to be a spacing order that defines the pool and defines the area. Parties have the opportunity to participate in that. If they think they're separate pools because there's 9 targets in a zone, they can come and make their case, and that we can break it down. But they have the opportunity. The due process is taken care of by having a spacing order. Then you go to the situation of drilling a well in a proposal. Okay, I want to read the statutory definition of consenting owner. 40-6-2 subsection 4 defines a consenting owner as agreeing to bear proportionate share of costs in drilling an operation. It says that right there. Agreeing to pay means you're going to pay. When you have a joint operating agreement in place already, there's remedies if you fail to pay. In the absence of a joint operating agreement, what is the remedy? There is no remedy. You have to take them to court on some kind of potential obligation there. But the point is, they agree to bear the costs. The costs are what the costs are. So it's not unfair to ask them to pay their share up front, particularly when under a joint operating agreement, the operator can cash call a person that says that they're going to consent. Okay? So let's go to the pooling order. The idea of a risk compensation or a non-consent penalty is to reward the people who assume the risk of drilling that well. That risk is set the minute that bit hits the ground. It's not sometime later when a forced pooling order comes into place. It's the risk at that time. So that's what you're dealing with there. And that's on a well-by-well basis. Nothing has changed on that. You force pool in a drilling unit. That's by statute, and that was argued in a brief in July. You force pool on a drilling unit, but you still maintain a well-by-well election to determine what is the appropriate risk compensation when that well was drilled. There's nothing different there. So when you're talking about costs, you're dealing with the costs. The costs are what the costs are. It's not unreasonable to do that. The operator and the other consenting parties are already committed. They're already spending money. Why would they stop midway just because they got to fight over a JOA? What Mr. Hunter and his clients are asking for is to say, no, we're going to wait. You're not going to be able to make a determination of non-consent or consent until there's a forced pooling order and you deal with the JOA. Okay? Now let's talk about that. When you get to the forced pooling order, there's all these Article 16 provisions that they're talking about and issues. Well, if you don't like them, bring them up. That's your opportunity to justify in front of this board. That's unfair. That's unfair. That's not the right way to do it. And since that statute was passed in 1992, Mr. Furlong is the only person that's ever challenged the JOA to my knowledge. And the board went ahead and dealt with that. Right there, due process. You can argue the terms on what fairness with the JOA. Due process is protected. Okay, let's go to the issue now. You've already got a forced pooling.
Let me interrupt you just a second, if I might, and I'm sorry for this. I want to make sure I understand what you just said on this first argument. Under the statute, this is under 40-6-2, subsection 4. A consenting owner means an owner who consents in advance to the drilling and operation of a well. I see that as different from some of the arguments that are being made here. And agrees to bear his proportionate share of the cost of drilling and operation of the well, close quote.
Just a point of clarification, the in advance may be the old version. I think that's the one that got removed. That's, if there's a citation to that, we might want to check the date.
No, I think it was the 2018.
My lawyer just tells me that's the old version.
It's the old version, yeah.
Okay, well then the next one, I don't know that it has been changed either. Oil and gas operations means to explore for, develop, and produce oil and gas. I'm going to get to that in a minute, but pardon me for interrupting you. Thank you for letting me do it.
Okay. The next point I wanted to make was the due process that's provided with the new 2018 legislation as far as applying a forced pooling order to subsequent wells. The process in the rule sets forth notice and an opportunity for the party to come forward if they think that the non-consent penalty for that particular well is inappropriate, then they have the opportunity to come in front of the board and make their justification, okay? It sounds like the way that Mr. Hunter and his clients are arguing that it's always the operator's duty to do all this. And I want to give you a quote from the Hegarty case that the Supreme Court stated. A good law, like a good parent, does nothing for a person that he or she can't do independently. The point is with due process is you give a party an opportunity to address these issues. And at each step along the way under these rules, that party is given that opportunity. It's a question of whether or not they want to undertake it. And those are the legal points I would try to make. The other issues, like I said, have been addressed. You've heard it ad nauseum in other hearings and addressing that. But those are the main points I wanted to make.
I have a question for you. On your proposed language, as I understand it, and I hope I have the right draft, it's on the definitions.
Okay.
And it's under the definition of joint operating agreement, or JOA. As I'm looking at it, we added that, and it's in blue. And then it's been changed to say oil, gas, and other mineral, and or other minerals. And what was taken out was the term oil and gas operations. But what I'm trying to do is we put the word oil and gas operations as a defined term under 40-6-2, part 13. And so you've added the term and or other minerals. What is the UPA's position for the other minerals?
There could be other circumstances between oil and gas. There could be, whether NGLs falls under that category or not, that's a potential with it. But it was a situation with an operator that expressed that they wanted to have that in that. We just included it in.
Because I read the definition of oil does not include any gaseous or liquid substance processed from coal, oil, shale, or tar sands. And then gas is defined as does not include any gaseous or liquid substance processed from coal, oil, shale, and tar sands. So I'm just trying to get an understanding of what is outside the terms oil and gas and substances produced from coal, oil, shale, or tar sands.
Well, that was the concern that was expressed, and if the board feels that its definition of oil and gas is fine, it's not that big a deal. It was just brought up by one of the members, and that was the concern.
Okay.
Just experience from Kansas, helium is sometimes located inside the mineral stream, and there's been a number of cases where is that part of the constituent stream or not. So it may provide some flexibility to operators that find something else that's good along with oil and gas. Give them some cover.
Now, board members, this is your time to ask some questions. Any questions about the landscape, how this whole system works? One of the things that we have tried to accomplish in the rule is to tell people the rules of the game or the rules of the system or the rules of whatever before they play. That's our primary goal, I believe, in what I've tried to recommend to you. So, anyone have any questions at this point? Mr. Moon, do you have some questions? Go ahead.
Yeah, Roxanne, I have a question for Roxanne. And Mike, if he's still there.
I am.
Okay. So, Roxanne, over the past 12 years, you said you've been working in the basin. How many disputed JOAs have been elevated to the requesting a board hearing?
For Newfield, none.
For Encana?
None.
And Mike?
For EP1.
Okay. He said one. And
Is that what you said, Mr. Wilcher?
Yeah. Yes.
Could you say that again so that the court reporter can get that?
I'm sorry. Just one.
One JOA that you've disputed to the board, or has been disputed to the board.
Yes, that has been disputed to the board.
And yeah, I would think that, our intent, as we've talked as a board, we hope that we don't have any more than that, maybe one every 10 years. We hope that non-operators and operators can work things out. But this rulemaking was necessary because of, the law. So let me ask both of you this. So assuming we didn't have an escrow requirement for the non-operator or the operator, what about this rulemaking makes it more likely that there would be disputed JOAs that rise to the board hearing level? In other words, without an escrow requirement, why are we more concerned that we're going to have a lot more of them? Therefore, we need to have an escrow kicked in by the non-operators to make sure that they have, the skin in the game. That's my question.
I think if I understand correctly, what Mr. Hunter has brought up on behalf of his clients is, you know, now, I mean, when you go and an operator force pools, excuse me, or goes to a force pooling hearing, it's to force pool a party, they end up being non-consent. If what I understand he's trying to accomplish is to say like that, no, that you can go through this process, go to the hearing, and still be deemed a consenting owner. And again, as I spoke of before, I mean, that's you know, that's that risk-free look at the well results. That's, you know, there's no risk taken by that party, but there's risk taken by everybody else. So, you know, I feel like there won't be a lot. I really don't think there will be a lot of instances where this will happen. But, I mean, the possibility that you can have somebody ride you down every time, and then decide whether they want to participate or non-consent, you know, months later, that's a risk for the operators. That is something, as we've said, that's going to be a little bit of a deterrent. It adds that additional element of uncertainty and risk for the operators.
But in order to write it down now with the new rules as proposed, they would have to be actively disputing a JOA.
Correct. Correct.
And knowing that that's going to result in a board action or a board hearing.
I mean, my understanding was the way the rule is being proposed is that this is a non-operator who says, I want to participate, I'm going to participate, I don't agree with the JOA terms, so I want to go to, you know, we're going to take this to the board. Again, where does it say that at some point during that process they can't just scrap it? If they're the ones that brought it in front of the board, what prevents them from you know, pulling it off the docket, just dismissing it and saying, we've decided we're going to non-consent?
And so I have a question to Mr. Hunter about that very idea of not being contractually bound until there's a final board order and having the ability to just jump out at any time once there's... Now, big picture, I don't see this happening very often. I think we're really debating things that aren't going to happen very often and talking about, you know, pulling capital out of Utah because there's this possibility, and vice versa. Both parties have, I think, kind of overstate the risks of what's going on here. But why is that fair for the non-operator not to have to put any money at all in? Because you have other non-operators that are, you know, that have consented, that are putting their money in. You're disputing a JOA, but like Mr. Gill said, if you're going to bring it before the board, there is going to be a JOA imposed. And the differences are going to be small, if there are any, or maybe there are large. But either way, there's going to be a JOA imposed, and the money's going to have to be kicked in then. You know, why not have that money being kicked in consistently with other non-operators? That's kind of my question.
The difference is, as Mr. Mayo pointed out, that if there are two parties that have agreed that the terms and conditions under which we kick the money in are agreeable, that's one situation. We're not dealing with that situation. We're dealing with a situation where the state, either through a field-wide spacing order like we're kind of moving to now, or a specific spacing order that has been handed down, these people are in bed with each other for whether they like it or not by state law. And so there is no one else to deal with. There's no one to turn to. These are the people that you're going to deal with. If I have received a JOA that contains terms which I believe are negative to me, I want to say, we need to settle this because this is going to hurt me. I would like to play the game. I'd like to take the risk with you, but these terms will make this non-economical. I would like this to be amended so that it makes this a good or economical deal for me. The operator says no. Well, we need to take this dispute in front of the board, because if we don't, Under the reg as proposed, I am now a non-consenting owner, because now, as you pointed out correctly, I now have an obligation to elevate this. If I want to avoid being labeled a non-consenting owner, I now have an obligation to take it to the board, which entitles hiring me, because no one else has done this yet. So it's going to be me, and I'm going to have to come here and make this case in front of everybody, just like I did with the JP Furlong, as Mr. Gill was talking about earlier. So that is a commitment. That's skin in the game right there. That is the skin in the game that the non-operator, rather than take a bad deal and chip in $27,388 on a deal that they think is terrible, that may end up losing them money because they're negative on the gas, they'd rather pay an attorney to come in here and dispute it and put on a case, take on a case bigger than they maybe should, to say this isn't right, this isn't fair, and this isn't just me. Every time you impose one of these, it's to every non-consenting owner. It's not just the person that's showing up here. You're right, the JOA will be imposed. It's kind of a done deal. Differences will be small, but it's imposed upon you, you don't agree to it. And that means you don't go to court anymore. You come back here, because it's a board action that imposes the terms of a JOA if you go non-consent. And so if there's a dispute later, or a joint interest audit, or anything else, we're coming back here.
We're going to take a break now, and we'll be back in about 15 minutes. Okay. Thank you. And Mr. Moon, when we come back, you'll be the one asking questions.
Test, test, test. Test, test, test.
Hello?
Microphone test, testing, 1, 2. Testing, 1, 2, testing, 1, 2. This is for the court reporter audio.
No. Or less? Okay. Court reporter? Technology? Okay. We are back on the record to you, Mr. Moon.
Okay. Just a different question that Chris and I were kind of discussing that we both thought of. Thinking about moving to the other part, just the one paragraph piece about the non-consent penalty for non-locatables. What do you see in other states as far as a maximum? Do they treat non-locatables the same as non-consenting sophisticated owners?
So the only other state I work in currently is North Dakota. It is treated differently. So an unlocatable is treated much like an unleased mineral owner. So in North Dakota, you've got a penalty for unleased mineral owners and a different penalty for a leasehold or working interest owner. Unlocatables are treated the same way. So it's very confusing, but the way the statute is written is that it'll say that the penalty for the unlocatable or the unleased owners is 50%. So it's 100% plus 50%. So that's 150%. And then the penalty for a working interest owner is 200%. So it's the 100% payout plus a penalty of 200 for a total of 300%.
Well, it's 300 and 150.
150 and 300.
Okay.
I know in Colorado that they're currently undergoing a review of the regulations, and I know that's one of the issues of trying to reduce that, what might be applicable to, but that isn't in place yet. Yeah. And in Wyoming, I don't think they distinguish it, and I think they just have a set statutory amount.
And I guess I would be remiss if I didn't mention, in Canada also operates in Oklahoma, and in Oklahoma, if you non-consent the first well, you're out of the entire drilling and spacing unit, completely out. So obviously a much more stringent non-consent penalty.
Any other states you know of?
Let me visit about North Dakota firstly. There is no penalty imposed if you haven't been able to serve the mineral owner. So if you haven't been able to give them notice, there is no penalty. So unlocatable mineral owners is the question that you were asking. Mm-hmm. So you still get your 100% back, but you can't impose a penalty until you can serve someone.
And that's the definition of a non-locatable, though, is you haven't been served, right? So is it 150 or is it?
You can't serve a dead person, which some have tried and then tried to collect the penalty, but you can't do that. So there's one case of unlocatables, but if you just can't locate that particular person, and you can't, if you don't have a signature from that person, then you don't get a non-consent penalty.
And then to take it to its full conclusion, the money allocated to that person is put in a suspense account. This is my understanding. Correct this if you're wrong, I'm wrong. And after a certain number of years, I think it's 6, but it might be 4 now, it is escheated, they call it, to the state, and it goes in the Uniform School Fund.
That is correct. You want
Right.
What would,
Mr.
It's still your
if you don't
turn.
mind. Actually, I've had opportunity to work on this just a little bit last year with Mr. Johnson, formerly of the board. Most of you are familiar with that. With Sitla now, he proposed some amendments to the probate code, and I got a little education about this. In Utah, my understanding is that even if the operator is required to turn the money over to the state for custodial purposes, the money never actually escheats in the traditional legal way. It actually is just held in trust by the state of Utah for the benefit of that person if they ever come forward. So it's I mean, it's a picky thing, but it never actually ends up belonging to the state. The schools have use of the money, that's correct. But if someone comes forward, it does that. And the other point I want to make about Oklahoma is that there's a robust statutory scheme that provides a very uniform and very regimented process for everybody concerned. And it's just common knowledge if you have any connection with oil at all. It's this Oklahoma way. And there was some testimony in the informal hearing from Mr. Adamson about that.
so just thoughts from the large operators on, you know, the idea of reducing that somewhat for the non-locatables, that the non-sophisticated, that don't know that they're consenting or non-consenting. What would that mean, or what would your thoughts be?
Well, as I mentioned before, and I think has been testified before in other hearings, is the problem is you're awarding the risk for people there to take. And that risk is what the risk is at that time, and it depends on whatever well it is. I would say right now at this point, you know, it's up to the board at any time. You have the ability to assign whatever penalty you want. I don't think it has to necessarily be uniform. But, you know, from the operator standpoint, the risk is what the risk is, whether
you know or not.
That's right. And if the idea is to reward them for taking that risk.
Okay, that makes sense. And just a little bit more, I just want to press this side of the room some more on the idea of being able to not agree to a JOA term. I understand, you know, you're not going to be paying in because you don't know whether you're going to decide to be in or out based on your dispute. But still, you know, the well is being proposed and it's being maybe started to be drilled. And why would it not be fair to require the paying in consistent with the other non-operators as they're billed, and then just depend on the board to you know, say yay or nay to the disputes and hopefully come out with a fair JOA, because you want to be in the well most of the time other than some disputes. So what would be unfair about that money that's being requested of other non-operators going into a escrow fund, or even just to the operator? Because in a way, you want to be in the well, you're just disputing some terms, and then bring it before the board, and hopefully we'll make some unjust terms just, or maybe make some, you know, whatever needs to happen. What would be wrong with that?
Absolutely. Go ahead.
Speak into the mic, please. Closer. You're not on.
Okay, under that scenario where it hasn't been disputed yet, what if somebody, if you can't come to an understanding, because they put these profit centers in here that are gonna wipe you out, you just agree to a JOA. Once you agree to it, it's on a cost basis. Once you agree to that, you have to, you know, you pay your money and you
Well,
go all the way through.
You don't have a signed JOA. You're saying,
Well,
we don't agree with that.
but what I'm saying is, they want you to sign a JOA that has all these crazy terms where they're able to make a whole bunch of money. But if you sign a JOA, if you can't come to an understanding, you sign a JOA that is on a cost basis. and then you pay your way, and then it's no problem. Then it keeps everybody honest. The whole key is we don't want to get over-operated to death. And as far as putting your money in escrow, in the past, what's good for the goose is good for the gander. Everybody needs to be on the same basis, because what happens is operators that may or may not have money and non-operators that may or may not have a big budget, what they'll do is they'll over-operate. They'll go out and they'll cash call the other guys to death, and then they'll take over their properties. So they'll send out 50, 100 cash calls, $10 million a whack. That's a lot of money. And that portion isn't fair. Both the big operator and the small non-ops need to live within their budgets and their means and cash call only what they can afford to put into the escrow account. That would be fair. So number one, everybody should be on you can't make money on your partners. Everybody's in on the same basis on the JOA, and then everybody puts their money in at this, whatever they're required to put in, we put it in. That's just my take.
Right, and that's, but I'm just saying that, let's just assume that they're not going to be, if they're doing some of those things, that's not appropriate. If they're cash calling before they need the money, not appropriate. But if they are having you put in, even though you dispute a JOA, dispute some terms of the JOA, you're putting in consistent with other non-operating partners in the well, but you're committed, you're contractually committed, and you're depending on the board to fix anything that you might feel is wrong. The concern from the large operator side is that you're saying you want to be in, but then there's time passing and there's information that's, as the well's drilled, there's more and more information, and that you jump out.
Okay, if you require us to be in, which is, they need to be in, we need to be in, because otherwise what's going to happen is it's going to be massive abuse, just like happened up in North Dakota. And
Aren't you both in? They're spending the money on the well, and they're just saying.
Well, I'm talking but that's, the type of money, whatever we have, if it's 5 million or 10 million, whatever you guys decide, everybody puts in that same amount in an escrow account.
Yeah, but who wants to be putting money in escrow, whether you're a large or a small? Nobody wants to. Escrow money's just.
Yeah, so if it's not good for them, it shouldn't be good for us. In other words, everybody should have to do it.
I completely
this should be
agree.
a fair system for
their
everybody,
money,
not just the big guys.
Their money is being spent on a well.
Okay.
The money they're asking from the non-operators is also being spent on a well. But they really, if you want to be in a well, they ought to have your money to spend along with theirs. No more, no less, just on a percentage basis.
And if you put money in escrow and say you've spent 2 or 3 million, once you put it in the escrow, you should be able to transfer it over to your bills towards the well.
Why not just get rid of the escrow? Just no escrow. No escrow. But I know you have concerns with that because it's kind of committing you to the well, and you may want an opportunity out. But if you're saying we want in except for some JOA terms, I'm saying you ought to be committed and depend on our board to fix anything that
Why don't you commit on a cost basis, and then if they feel that their costs are just and reasonable, they come before the board and prove that, hey, we're charging these big gas fees and these big water fees, and we want to ask you, board, is this just and reasonable to the 50,000, all the mineral owners in the Uinta Basin?
That's what'll happen when you come before the board.
Okay.
That's what'll happen.
I'm going to wear both hats here. So from an operator standpoint, you want to be able to get paid from the non-operators, obviously. And so this cash call idea is fine, except that there are issues with that also. I mean, I've paid cash calls before, and the operator didn't get them drilled, and it took me a year and a half to get my money back. Now, I think that you tried to put some things in place here that would resolve that, but that's still an issue. The other issue is, if I'm paying drilling and completion cost up front, I'm under wells now that aren't being completed a year, 2 years. So, I mean, why should they have the use of my money? And there's the other, here's another issue we've had. During that time, they've changed operatorship. The first operator tells me, well, you have to get it from them.
Well, that's on wells you've consented to.
That I've consented to. And the new operator says, well, no, they have it. So
is that happening here in Utah?
Not yet. Not yet. I think that's why we were trying to address all these things early on.
We can't fix every possible.
No, you can't.
Scenario. We can just,
I'm going to defend myself a little bit by saying, the reason this started is because these things weren't in place. In most places that we operate, we know the rules going in. So here, we get a JOA 6 months after the well's already being produced. It's a little unfair to the non-op because they can write the terms of the JOA in any way they want to write them, and I think the biggest problem is transparency. Amongst operators, are they making some sort of deal? Do they get a different JOA? Hey, this is how we do things. It may not even be under a JOA agreement. It could be under, as I think was testified, as that we have wells over here, you have wells over there. The other thing is a lot of these times you're going to remember these facilities, these pipelines are owned by several of the operators in the area, not just one. So sure, they don't complain because they're all part of the ownership. There's just, it's a transparency issue, I think, is probably the biggest thing. And the same thing with JOAs. Are you going to show me the JOA or the agreement that you entered into with someone else so that I know that mine's fair or not fair?
Yeah, so I just want a response from this side regarding the idea of the owner that has a dispute in the JOA paying their costs just consistent with what other non-operators are paying when it's asked for, when there's cash calls or however it's done. If there's a commitment that they are in the well, subject to the terms of what ends up being the board decides as far as the terms in the JOA, would you still need that or feel like there's a need for that escrow skin in the game?
You got to remember that the whole point of the escrow was because of requests that they made to protect their funds and also to make sure that the operator commenced operations within 120 days. You have to refund the money. It was meant for the protection of them. The other thing is again, with the escrow funds, it's in a trust account. I mean, there's protections meant there for that to be done. If there's not completion issues, and if they didn't do that, I would assume that there's options to force the operator to do that and not sit on it. Terms of a JOA could address those, that they have to have a completion. The 2015 JOA has a numerous provisions, including dealing with affiliates. It also deals with timing on when you have to complete a well, horizontal well. So, I mean, there's all kinds of options with that. The problem is anything that sits in escrow, if you can't take that out as the costs are being incurred, they get the time benefit of that money in that escrow until a JOA is in. And then, like I said, is that the point when they're deemed consent? After all of this and after all that's been done and you don't get the access to the money?
Well, I'm going to ask if I can come back to you. We're going to start losing witnesses at 3:15.
Can I just make one? It's going to be real quick. I mean, so we're talking about these protections, but who's going to implement those protections? Is the state going to say this is what's going to be in each JOA minimum, or something like that? This is all great, and I think that that resolves a lot of things. But the problem is, are you going to rely on the operator to put those things in place, or is someone going to say this is a minimum in a JOA? Thanks.
Thank you. Board members, any other questions? Go ahead, Rich.
Oh, I believe it was stated earlier that that JOA disputes have risen up to the board level where we've actually gotten involved once or twice in living memory. Is that correct?
Just one time, EP and Furlong, so it's same people were in the same matter.
I was actually going back to before I was on the board to see if there's any others. Is this a rule in search of a problem? If most of this rule went away and we went with the status quo, what would happen? I'd love your opinions on that.
We'd be back in front of the board and trying to argue these things out and then possibly litigation, I guess.
We'd have the same problem with the non-ops who want to consent, say they're going to consent, and then no way to enforce it. Until we come in front of the board for forced pooling.
Right. Which just happened one time.
It'd be nice to be able
Okay,
to figure this out so we take the board out of some of these things. I mean, otherwise the board's gonna be inundated with these.
Thank you.
Can I just follow up with that?
Yes, I interrupted Mr. McDonald. I believe he had another point, but go ahead and ask your question.
I guess I'm just curious, you both have pretty much said you'd be back up here right away. How come this hasn't happened but once in living memory?
Cost of wells, I believe, it's a little different times for one thing.
And horizontal
Horizontal wells, much more expensive.
But the industry
On
is,
people's part, so.
I don't want to testify, but, I mean, I would hope, okay, Mr. Welcher, Ms. Eveland, can you go together and sit down and negotiate every JOA? Can you fly over there, or was it designed to be set up so that it was a standard agreement set forth by the AAPL with amendments and choices and elections that are allowed in it? But you really have to do it remotely, don't you? Because you just don't have the time to negotiate every single.
As far as whether or not you're negotiating in person versus negotiating, over the phone and email and everything. As far as what's your basis is an AAPL form operating agreement. That's always your basis. Things that are negotiated are obviously, things that you put in the Article 16. I'll say Newfield, prior to the AAPL coming out with a horizontal JOA, still was using, one of the older JOAs, but knew that we were drilling horizontal wells. So we kind of used that Article 16 to help steer that JOA more towards horizontal drilling. So, you're hearing a lot about, this Article 16 and these onerous provisions about water and gas gathering. But Article 16 is other things too. And so one of those is if you're using one of the older form agreements, you use your Article 16 to tailor that JOA more towards horizontal drilling. But, do Mike and I get together in person? No. Most JOA negotiations are done, over the phone, over email, and that's the benefit of our technology. Certainly I think if we had to do them in person, I don't know, they may never get done. But
Well, take the standard AAPL agreement, JOA for horizontal wells. What percentage of that JOA would be unchanged, just standard language that everyone would accept, and what percentage of it would be possibly up for dispute, including Article 16?
So are you referring to the horizontal JOA?
Or just, if you've got a standard industry agreement in the field, whether you're using an old one to bring it up to speed to the modern drilling or whatever, what percentage of that agreement is standard industry practice that you accept that either as the operator or as a non-operator?
And I would say outside of the Article 16, the things that you're negotiating the most are the fill in the blank things. Okay, so non-consent penalty, in the COPUS, your drilling and overhead rates and things like that. I want to give Mike a chance to answer that as well. He may have some different thoughts.
Well, for us, we always start with the AAPL form JOA. And I would say, most of it is accepted standard industry practice and doesn't get much, isn't debated much. There are the things that Roxanne mentioned that are the fill in the blanks. But the AAPL form is a form that's has to be amended to some degree depending on the basin, depending on the specific operating basin that you're in. And so a lot of the things and a lot of the changes that we make for that we negotiated between EP Energy and Newfield at the time were around the types of ownership interests and how we were going to deal with this situation, who pays what if a party goes non-consent, if they own tribal interests, for example. Those were specific to that situation. There are other things in the Article 16 that we put in because we're in the Uinta Basin. There's some things that we put in there because of experiences that we've had. Every company has different experiences, things they've run into, and they make the adjustments in the Article 16. You know, it's hard to say that 80% of the JOA is always accepted. It depends on what basin you're in.
Thank you. Mr. McDonald, we interrupted you. Did you have any other things to say?
Just had a couple other legal points that I wanted to address, and I apologize I didn't get them in my earlier comments. First of all, the idea that one well per drilling unit is kind of gone out of the way. The statute clearly recognizes the possibility of infill drilling. The idea is you always start out very conservative with the on the data that's developed. It may be that there are additional wells that have to be drilled. The concept that it's just one well per drilling unit is kind of gone by the wayside. So I just want to say that. The other thing is Mr. Hunter brings up the unitization statute 40-6-8. He's kind of mixing 7 and 8 together. 7's very broad, 8 is the very specifics, and he cited that. The board may remember, I don't know how many of you were on the board at that time, but there was a hearing several years ago with Petra Hunt where they tried to make a fee compulsory unitized exploratory unit. And the problem with our statute is it talks in terms, one of the elements has to be that it's based on incremental production, which is tied to secondary recovery and the specifics that are set forth in the statute. You simply cannot compulsory unitize for an exploratory unit. If that was the case, you'd be seeing a lot more federal units in front of you to get everybody as part of it. You just can't do it. So that's why you have drilling units and pooling. So you need to separate that. It's not all resolved by 40-6-8. The system is with a drilling unit, you go pooling and a drilling unit in that situation, and you unitize under the statute for the specifics that are there that have to deal with incremental production and the allocation. So those are the 2 points I wanted to make.
Ms. Evelyn, we know you have to leave. I have a question for you. Let me premise it by saying this. What we wanted was to set that a person would be a defined consenting owner under 40-6-2 subparagraph 4 at the time that they objected to the JOA. We thought that one way to do that was with the escrow account, and that was put out. But what if, just throwing this out, it's a follow-up to Mr. Moon's comment, and I'll go to both sides. What if a JOA is proposed that has been accepted by other non-working interest owners, all that would have to happen, no escrow would go away, but they have to either certify or proffer or something that says we're contractually bound by the well as defined by that subsection 4 as a consenting owner. And the operator then says, yeah, I agree with that. They are bound. I don't really care what arrangement that is. What would you say about that? And then they can, they've got skin in the game. They have the liability of being taken to court for their share of the costs, that they've agreed to pay the costs, and they're just going down that. Mitch, you can come join us here. Grab your chair and come up, and we'll talk about that. I'm going to start with you, Evelyn, Miss Evelyn, because you have to leave.
Thank you. I appreciate that. You know, at its basis, I mean, the request that, and as Mr. McDonald stated, you know, originally the operators in UPA had come forward with that they should pay their drilling cost upfront. It wouldn't be put in an escrow account, actually be put towards the cost of the well. And as he stated, the escrow account was more to say, okay, you know, if you want to preserve your right to participate, and you put your money up front and you put it in an escrow account because you're more protected. So in my opinion, I'm not a lawyer. I don't know how the mechanics work, but there is no difference between having them put their money in an escrow account and having some other contractual obligation that binds them to pay that money at some point, because when their money's in escrow, we're not able to use it to pay the bills anyway. But to me, it's serving the exact same purpose.
Mitch?
Sorry to jump in. If there's any more questions for Ms. Evelyn, we can come back to this if the board has a lot more they want to ask her. But I was just trying to clarify from back there. I was having a hard time understanding. It sounds like Mr. Moon is essentially saying, let's say we scrap this escrow thing altogether and go back to, you put your money in, you give the operator your money, and you just trust the board to call balls and strikes, which is their job. And then Chairman Gill, some sort of variant on that. What if we do that, but we do less than a contract, but kind of a more or less we agree to be contractually bound?
As a consenting party.
Okay. Yeah, and I think, you know, maybe a hybrid, and I haven't talked through this with anyone, but as I'm thinking, one of the requirements we've built into the rules is submitting in writing objections to specific provisions of a JOA, and in some contexts, not oil and gas related, but in some legal contexts, you have people sign contracts under protest. You know, some sort of, I'm consenting to the well, here's my money, here are the specific 4 or 5 provisions that I'm disputing, and I'm going to leave it to the board to call balls and strikes. And in that situation, the board could set up a scenario where this consenting owner was participating in the well and they were to be bound by the JOA. Every term that they did not in writing object to, and every term that the board makes a conclusion, this is just and reasonable, this is just and reasonable. Whatever the board determines on those disputed provisions, it may be the same thing, because I'm afraid of creating different types of contracts, different types of accounting procedures. You know, really, we've got the mechanisms there. It's about figuring it out so that they don't have to put out money they're not going to get back or see any return on, and that the operators don't have to go chasing down money every time they see that they could have made a better investment and they change their mind.
McDonald, then we'll go to Mr. Hunter.
Okay. Again, it comes back to the problem that when you talk about the other consenting owners, a JOA is in place, and there's remedies under that JOA. There's plenty of things that they can do without having to go to court. If you do the concept that somebody can simply agree to a contract and then breach it, then it goes to the operator to have to go to court to collect that money. And the idea is, if you're committed, and when you talk about skin in the game, this is what I'm talking about, you're committed. The costs are what the costs are, you're agreeing to pay them, pay them.
And as from my understanding of the industry, by doing that, you're no longer a carried interest, which is something you can create. A carried interest is where you still have your right to the proceeds, but you don't have to pay your costs. That's the definition of a carried interest. Until you are consenting, aren't you in fact a carried interest if the other parties decide to go forward?
You would be carried, except that you would be then netted out, or the operator would come and get the non-consent penalty at that point because they haven't made an election.
Mr. Hunter, I'm going to go to you in the interest of time. Ms. Evelyn, thank you for your testimony and for coming all this way. How far did you come?
Oh, came from the Woodlands, Texas, so.
Thank you. In a snowy day.
It's not snowing there, so I want to go back. Thank you for your time.
Mr. Hunter, what about?
Short answer is yeah. Okay. There's a caveat, but
what's the
yeah.
caveat?
The caveat is that the middle ground that we're looking for, there's the statutory arrangement that's controlled by the law. Then there's this contractual arrangement that winds up happening if you either voluntarily agree or by the operation of law, once it's been imposed, a contractual relationship of some kind springs into existence upon the entry of the order. We're trying to bridge the gap. If the bridge is a line on the AFE that says something to the effect that non-operator hereby agrees to pay column 2, lines 4 through 7, whatever that ends up being. And I think Fred and I could probably hash something out. I believe the UPA's goal is to find a contractual hook to change it from a purely statutory situation to something contractual. And I think that might be workable.
And that's exactly what I was saying. I don't want to predefine that. But if you can come and say, we've got an agreement that I'm consenting owner and I'm under the definition of a consenting owner in the statute, we're fine. So I don't really have to see the document. I don't even need to see it at all.
You're right, you don't.
I think that's been very helpful. Anyone? Okay, any other questions on the board? Okay. Let's go back to anyone have second thoughts, and I'm going to call that, I'm going to start with you, Mr. Hunter, rebuttal or sir closing arguments?
Yeah, however that winds up being, I have a page full, but I don't think I'm going to go through all of them, especially given maybe that there might be some additional work that we might be able to do to resolve something. Just to get to Mr. Moon's question, which I don't think got fully answered, that the equity part of this, the part that's fair, is time and information, which you sort of pointed out, and I scribbled that down. The timeline from the EPE case back years ago and the information that is let out is the crux of this. The timeline is under the control of the operator. The timeline is dictated by their capital schedule, as we heard from Ms. Evelyn. It's dictated by their drilling contracts that they've got. They can't have a drilling rig idle. Their lead times, as Mr. Walter said, were 5 to 8 months. That's plenty of time to squeeze in a hearing, especially if we've got these clocks in there. 30 days, 60 days, maybe a hearing or a decision in 30 days, something like that. That's 5 months, 4 months. So I think that the timing issue has always been in the hands of the operator, and the non-operator has absolutely no control over that. So that is it's clearly on their side. The information part of it, and I'm sad Ms. Evelyn had to go, but people talking is not notice. People hanging out in the basement at the coffee shop does not constitute notice. And as I pointed out in the last hearing we had, these wells are kept confidential for a year. So there's no official information that the non-operator can get or is entitled to get, especially if they haven't written their check or paid in. The operator is not going to share that well information, and perhaps rightly so. I think I understand their point. I think we all understand that point. But there's no additional information that's out there that can let someone, quote, ride down the well or game the system reliably so that you can just hold things out. And again, if we have these clocks in the reg, it won't last that long. 5 months, 6 months tops. I heard the words deterrent and disincentive. And this goes to Mr. Borden's question, what are we doing here to change that formula? Are we going to re-incentivize people to come to Utah if we put in the escrow and the prepayment and all that stuff? Is that somehow going to put Utah a cut above everybody else? And if that's true, why is that? Is it because you can just propose whatever JOA you want and people have to take it? That doesn't seem like a very good way to differentiate ourselves. Is it because, as has been Mr. Gill has kind of put out here, is it because once you've got an AFE signed and an election letter signed, you kind of know they're in? And I'm sorry to say, Mr. McDonald, if you do have trouble collecting, you go to court. That's just what you do, and that's just how it goes. And that's fair for everybody. That's fair for the operator, it's fair for the non-operator. If there's a dispute, you go to court, and that's how it is. A difference I heard between some of the things that Mr. McDonald was saying and some of his witnesses were saying is that Mr. McDonald pointed out that we are given the right, the constitutional right to participate, to do these things. And his witnesses were saying we have to do something to preserve the right. There's a difference there. We, under the proposal as it is now, we have to take affirmative steps as a non-operator in order to keep something which was otherwise ours. That is the main problem here. Conditioning access to the administrative body to redress of grievances on the payment or participation somehow in a scheme which you've already determined maybe isn't the best idea for you. And I think that's a key difference that we need to keep in mind. The other key difference is about the wells in the unit versus the well. It's Mr. Mayo pointed out that it's all future wells. No, it's subsequent wells, one well at a time in sequence. It's still a well by well situation. So we've got to keep that in mind as we're going through this here too. And Mr. McDonald's point is well taken. I think I heard a two birds with one stone proposal here. If the problem in the unitization statute, keeping us from getting federal exploratory units and maybe solving a lot of these problems, is just the incremental production requirement, maybe that's something that could be explored legislatively. That really would maybe differentiate us on the national scale. If we could put together large exploratory units and have protections of correlative rights, the incremental production, geologically speaking, is really good evidence that most people should be banding together, but maybe we can come up with something else. So I have, like I said, a whole page of stuff, but if we're going to work on this new proposal, that may all go by the wayside. So at that, I think I might just close out and thank the board for the opportunity to testify and to present.
Thank you. Mr. Walcher, are you still there?
Yes, sir.
I guess this is a generic question to everybody, but any second thoughts or anything you believe we didn't understand what you intended to say by the questions we asked? Did you feel like we understood what you wanted us to know?
Yeah, I think so. Generally, I just feel that that to allow a co-owner to avoid paying their share, like the other co-owners who have executed a JOA, just by disputing a JOA and getting an extra 3 or 4 months to look at wells is not fair to the rest of the co-owners. I think also if we were to have a escrow account that the operator also had to put in its working interest share, like I said, $10 million or whatever it was, $9.5 million versus whatever the co-owner share is, that's leverage for more co-owners to say, well, hey, let's just dispute the JOA. The operator will have to put in several millions of dollars. They're not going to do that. They're just going to cave on the JOA terms to avoid having that expense. So that I think is one of the.
Okay, let me rephrase what I just heard. Would you mind if I rephrase what I just heard you say? If in essence you have someone that is a consenting owner and it's not escrow, but it's the equivalent of a cash call that could be used, what would be your response to something like that?
If the co-owner who is disputing a JOA had a cash call and had to pay
their
share,
feasible? Yeah, I mean, in essence, the operator already has the money. They're going to spend it on the well. They do a cash call for themselves. And what I'm trying to say is, let me say it a different way. If you were king for a day and could avoid the North Dakota problems where people ride the well down, get the information, have previously said they're consenting at the beginning or middle of drilling the well, and then they say they're not consenting, what would you do to solve that?
I would have the signing of an AFE and election to participate be a commitment. I would also, just like, if they want to dispute the JOA terms, that's fine. But in order to do that, they have to submit their share of the dry hole costs, just like the other co-owners do who have signed JOAs.
Everybody understand that? Board members, do you understand what he just said? Okay, Mr. Mayo, if you were going to solve the North Dakota problem, as I did just defined it, and you were king for a day, what would you do?
I would probably give up my throne. I don't envy the task you have. Yeah, I don't think there is, really a solution. I think what you have to do is figure out which of the bad options is the best. And I think that sounds flip, but it's not intended that way. I think that's any adjudicative body's job, is to make hard decisions and say, listen, this impacts these people in this way, and these people in this way, and these unknown people in unknown ways. But based on what we know, this is the decision that makes the most sense for the most people in this context, upholding the rights. And I think one of the points Mr. Hunter made just now in his rebuttal closing statement that I did want to address, and I'll do it in conjunction with this, is this notion that the board is imposing on people this obligation to pay, essentially, to have their legal rights recognized, that they have to put up money in order to seek redress. It's nonsense, if I can be totally blunt. It doesn't exist. That's not what's happening. What's happening, and I think to tie back to your question, is this board's job is to put everyone on a fair and equal footing as best as you possibly can. I'm not presuming that Conoco, to pick a major oil company, and a mineral owner in the Uinta Basin are on equal footing, nor am I pretending they ever will be. But the reality is, if they are both mineral owners in a well in the Uinta Basin, they can be put on an equal footing by this board by saying, here are the rules. The rules are, you have to elect within a certain time frame. And with that election, there has to be contractual obligation, one way or the other. You either are in, and you're in, or you're not in. And I understand the need to negotiate contracts, but one of the things that hasn't been discussed at all, Mr. Hunter really is here on behalf of quote unquote the little guy. I think that's the position that he's put himself in. And Mr. Furlong, Mr. Wixom, they run successful companies. They've been in the oil and gas business for 30, 40 years. They're obviously really well acquainted with what they do, and they've got really good legal representation here to push their agenda. And I think what we have to remember is, there's nothing saying that they couldn't proactively. I mean, how many operators are there in the basin at any given time? 5, 6 that are really actively operating, that they couldn't go out and set up a meeting with EP and say, hey, listen, EP, we'd like to sit down. We have interests in 45 sections in your area of operation. We'd like to sit down and work out some of these JOA terms in advance, just like EP and Newfield / Encana have done. This is something where the problem is we're all here concerned about protecting people that actually aren't here asking to be protected. We don't have any single mineral owners here saying, wait a minute, but I don't understand anything about oil and gas and no one's looking out for me. Everyone in this room is geared at protecting people who don't understand oil and gas law. That's why this entire body exists. What we have is we have an oil and gas company, A, and an oil and gas company, B, coming in saying, but you're not looking out for me. And that's the decision this board has to make. And so I think to go back full circle and to end it, what I would say is equal protection is probably the fundamental of all concerns. Due process, we've heard a lot about due process. There is process afforded throughout, whether it's enough process or a long enough process, that's a different story. But there's due process, undoubtedly. And so putting everyone on an equal footing is really how you solve this problem. And I think the only way to do that, given the huge disparities in financial and knowledge between different parties that you'll see before you in any given matter, the only way to do that is to give a date certain. Say, you're all treated the same. By this date, you have to do this. If you don't, we will consider you this. And so that would be my outcome, would be to say there has to be a date certain, and after that date, you can't consent.
Mr. McDonald, same question.
Well, I think we've already stated our positions with all of this. I think it's only fair that you put the non-operator in the same position that people who are consenting parties under a JOA. And part of that is a cash call, and it's a commitment. You shouldn't have to go to court to have to do that. Under the JOA, there's all kinds of remedies. You can set off. You can declare them non-consent if they don't pay. There's all kinds of remedies under a JOA that you don't have if there isn't a JOA in place. So if you're looking to, if it's short of payment, and assuming if there's payment, there would be entitlement to certain information that's gathered because the money's already in there. That's the part and the fundamental part that I don't understand. Why is that so unfair to deal with? I totally agree with Mitch's assumption on the issue that this board is the one to make the decisions. Why can't it be fair? You make your arguments here and the board determines what it is. It can be right under our statute. The legislature's directed you. It can be the operating agreement that the operators put in front of you. It can be the one the non-operators put in front of you. It can be the one that governs the majority of the drilling unit. Or it can be whatever terms you think are just and reasonable. So that's the opportunity there. I'm just having a real hard time having to have an operator go down the event of spending the money in court to have to collect an issue while the other person can just sit down and decide what to do with it. And the end result being that possibly that they get to ride down and go non-consent anyways. So it just seems to me it's fair to put them on the same rights that any other person under a JOA, and if that's a cash call to put the money and protect them, then they should put it up front. That's the skin in the game.
Mr. Furlong, I'm going to ask you that question.
Okay. Firstly,
To avoid the situation in North Dakota.
yeah, okay, I'm going to
That's the question.
I'm calling it to avoid the situation in Utah, but we can call it as we may. Fred is correct when he says that the JOA will resolve a lot of these issues, and it gives you the the basis of how the non-operator and the operator agree for the operator to drill the well. This notion that I keep hearing this, and it's really not true that the non-operator is looking for some way to ride down this well for nothing. That's just nonsense. That's just some painted picture here that is incorrect. With the non-op, what we're looking for is a way that we don't get strong-armed in the well or strong-armed in other situations that may come up within the JOA, may come up during your negotiations on that. I don't think I wouldn't have any problems with paying a cash call. I don't want a cash call to be paid on the completion cost up front. I would pay it on the drilling cost. That's not a problem. I also think that there's a time and place that you do that. For me, I would like to see, okay, let's say you have, I don't know, we can call it 10 days from spud date. Otherwise, I'm paying them. This money's sitting there. They may not do anything for several months. So talk about fair and equitable. I mean, both parties have an issue. I've been an operator. You want to get paid. You want to have your money because you put money out there. But as a non-operator, we're starting to see where in North Dakota, we don't have a JOA, but we're seeing where we get jibbed in advance for completion costs that haven't even happened. There's just a wide area of abuse there that can be abuse. Not all operators do that, and not all non-operators don't pay. So that's the nature of the industry. You're always going to have that. And I don't think that you ever everyone's going to think everything's fair. I think you just have to have it so that there's some way that we're all on the same playing field and the same, rights that you have as a non-operator or an operator. That's really where we're trying to get. All this escrow issue I think is going to be a mess. I think that, as you proposed earlier, to the notion that we might get rid of that, I think that's a good direction, really. It's just that this idea of when we pay our cash calls, otherwise if they're just holding it and they're not spending it, then we're funding them just like they're saying they're funding us. And so those are the issues. I hope that answers your question.
I think it did. Board members, last chance.
So the way I understand it, kind of this discussion that we've had is that both parties would be okay with, if there's a dispute on a JOA as long as the non-consenting owner who disputes the JOA is paying the money consistent with other consenting non-operating owners and retain just with the and that they spell out the JOA terms that they disagree with, and you can't come to an agreement, and it comes before the board. What are we missing? Doesn't that resolve both sides' concerns?
The other concern is, I know this for a fact because I've been an operator. I've also worked for 2 major oil companies. We don't always amongst operators or some we'll just call them, say, EPs over here and Newfields over here. We don't necessarily have them sign. We make other agreements. So it would be nice if it would be transparent, so that actually as a non-operator, you know that you're getting the same deal as someone else and are going to be subject to the same terms. You can't. I don't think it's right to say. And we did this all the time. I'm not saying that we weren't guilty of it. We made different deals with another operator than we did with a non-operator, but it's being abused at this point in time, and that's where some problem is. And the other thing is, we didn't make other operators pay cash calls. I mean, we just took it as their credit. So there's all kinds of things that go on here. Transparency needs to, I guess, be in place to make sure that everyone's playing on the same playing field. And I think that's all we've ever asked for.
You say cash calls, though. We're not talking a different cash call to the disputing non-operator. We're talking a cash call consistent with what's being sent out to all the other consenting
that was my
owners.
point. Is that actually being done?
Well, and if it's not, then that's where you bring it before the board and say, and because the large operators don't want to be called on things that are on their face not fair, and that would be to cash call before you're going to drill a well.
It takes an awful lot of policing to say that we're actually going to know that someone else is going to do that.
Yeah.
So I don't know the answer, but that's where some of the problems arise.
You would know if you got a cash call and nothing's happening at that well site.
Yep.
What's gone on here? To give us our money back or drill the well?
Yeah, that's true.
Your point there is exactly right on. It's the consistent with, and I think the process here is AFE election letter. There has been expenditures made. There has been activity done, well site prep. All these things have been happening in the background through their paperwork process, and Mr. Walter described. All this is happening at the same time, or roughly in the same time period. At some point, the estimate, the AFE, is going to become a reality. Is going to be a JIB. You're going to get a joint interest billing. That is the part that is the consistent part. When everyone else gets jibbed, this person that has a problem with the JOA should be getting jibbed at the same time. We don't get a special jib because we're angry about the JOA being not fair or whatever. We get jibbed at the same time everybody else does for the exact same amounts. That's the consistent with that I want to point out what you're saying.
The JIB is the same as a cash call, is it not?
It is not.
Okay, what is the difference?
The cash call is what you request or demand if you have a JOA in place already of your non-operating working interest partners. You say, we're going to spend this money soon, send us a check. And that's a provision under the JOA. What we're discussing here is a separate quasi, it's a contract, it's real, but it's an agreement to pay consistent with other non-operated interests who get jibbed at time X. Whenever that is, that EP has in their own internal process, okay, we've spent this much money on the well, there's title work, there's road work, there's a spudding rig. Everyone's getting jibbed for that stuff now, and so does this annoying little small operator who wants to argue with us about Article 16. They get their jib at the same time.
By the same token, if there is a cash call,
sure. If everyone got cash called,
then there's no reason that
if everyone got cash called, so would we.
All right, board members, let me see if I can wrap this up. Anyone feel like they don't understand the testimony today or need additional questions or need to prolong this by asking more questions? Anyone out there in the audience that feel like the board needs an additional comment or three so that we understand what you're saying? I think we've gone down the road pretty well today. I do think that the comments that we've heard have been excellent. They have not been we haven't heard them before, so thank you. I appreciate it. Okay, then. The plan is then that we will discuss this rule at the December 11th meeting. Board members, I would caution you about discussing this with more than 3 members, and that would be before, that would require a hearing. So we're going to discuss this at the December 11th matter.
That's more than 3 board members at the same time. But individually, we can talk all.
So with that, a motion to adjourn is in order.
So moved.
Second.
Okay. Any discussion on that? Well, it's non-debatable. Up or down? Okay. All in favor say aye.
Aye.
Any opposed? Let the record show that that was unanimous. We're now off the record.
Thank you. Thank you so much.
Thank you. Thank you all.
Thank you.
Thank you, Mr. Walter.